This conference will now be recorded.
You never know. It's really, I don't know. I mean, I will say. Yeah. Yeah. So it's not like really serious. I just
Okay, are we ready? Good evening. We will call this May 4th meeting of the zoning board to order. Roll call, please.
Paul?
Yes.
Here. Maxley? The planning manager? Ballman? Meisinger? Here.
Here. Thank you. Before we get started tonight, I'm going to give an explanation of the meeting procedures. I would like to thank the zoning board members and the staff for your patience and attention Tuesday night. We went an awful long time, and I thank you sincerely for your attention and patience. So. Okay, the zoning board conducts a public hearing to take sworn or affirmed testimony from all interested parties, both supporters and objectors on each case that appear before the board tonight. This is the only opportunity you will have to present testimony in opposition or support of the petitions. Only those interested parties that have submitted notice 24 hours prior to tonight's meeting are allowed to cross-examine the petitioner. This is an opportunity to only question the petitioner, not to make statements or offer personal testimony. Upon final questioning, the interested parties may then make their closing statements. Others appearing here tonight and wishing to speak before this board must fill out a form located on the table in the back of the room and turn it in to Jackie or Melissa, and you are allowed to make statements only. You cannot ask questions. Groups that oppose a petitioner's request are asked to appoint a spokesperson to speak for the group in order to avoid repetitious testimony and save time. Repetitious and off-the-subject testimony may be ruled out of order. Please refrain from repeating and be as factual as possible. Now, following the public portion of tonight's hearing, the zoning board will enter into deliberations where they will make a finding of fact based upon a variety of different considerations. The board is not bound by strict rules of evidence, and it may exclude irrelevant, immaterial, incompetent, or repetitious testimony. The zoning board does consider the following when deliberating on all cases: the county zoning ordinances, the 2 county comprehensive plan, 3, the county land use plan, 4, local municipalities comprehensive plans, the public benefit, and 6, the best interest of the county. Okay, so tonight is a update of our zoning code, and only the county board can approve new code. And so the zoning committee will make a recommendation, and then it will go to the land use committee where they will make a recommendation, and then the county board meets at the end of the month, and they are the ones that will have the final decision on the codes that are on tonight's agenda. Introductions tonight. I'm Chairman Dwayne Lesson. Jackie is our Community Development Administrator. Matt is our Assistant State's Attorney. Alec Messina is our consulting attorney on this situation. Cindy is our reporter. In the first row here is the zoning board members, and the second row, the land use committee members. Okay, we don't have any minutes from the last meeting. We'll take care of those next month. And so now is an opportunity for public comment on any matters not listed on tonight's agenda. Does anyone have any public comments on any item or matters not listed on tonight's agenda? Question? Yes. No, you are signed in and you've signed in 24 hours prior to tonight, so you are allowed to ask questions and cross-examine. Yes, like I said, we're gonna be rather focused on the code tonight. So if you start going down a path, you may get shut off because what's on the agenda tonight is the code. But your testimony is related to the items on the agenda. Yes. Okay. And then I'm going to reiterate, please refrain from repeating. If someone ahead of you has brought up a item and you tend to agree with that, rather than giving a whole spiel again, just say, I also agree that with whatever the person's name is and because like I said, we're not going to go till 1 a.m. tonight. Okay? Does anybody else have any other questions before we get started? Okay. I'm going to read this one. Okay, our first case tonight is 23-29-A. Petitioner is Tazewell County. Proposed Amendment 65 to the Tazewell County Zoning Code. This amendment relates to notice of public hearings, okay, and the publication of those hearings. And so you can see that not less than 15 days, and then in bold letters, not more than 45 days was added before such hearing. And then the last sentence was struck out of our old code, so the new proposed code would end after 45 days before such hearing. Okay? Health Department and Soil and Water made no comment. Farm Bureau had no comment. Tazewell County Highway Department had no issue. And John Oliphant from the City of Washington supports the changes. Okay, Jackie, is there any other information we need?
So there was an amendment in January. That's when we changed to the classification of the A and B at the desire of the county board to weigh in on the Class A requirements. This was included in that amendment, and it conflicts with then what the state in Public Act 102-1123 required as less than 45 days notice. We had done or amended the ordinance to state more than 45 days. So this is just amending what we amended in January to be compliant with the state.
Okay, zoning board members, questions? Land Use Committee? Okay, we've got a couple people that want to right, let's do them one at a time. We'll just keep them in order. Kelly Sands Reisinger. Okay, name and address for the record.
Kelly Sands Reisinger. I live at 25880 Boynton Road in Delavan, Illinois.
And you hereby swear or affirm to tell the truth, the whole truth, and nothing but the true self you got.
I do.
Okay, your comments?
Good evening. Thank you for allowing me this opportunity to speak as an interested party regarding the proposed amendments to the wind and solar ordinances here in Tazewell County. While I have not had an ample amount of time to review all the changes, I trust that the United citizens of Tazewell County are familiarizing themselves with them and can testify to those on my behalf. I come to you today as a professional businesswoman and caring citizen of this community because I have concerns related to case numbers 23929A, 2330A, and 2331A. I will address some of these concerns shortly. I have committed myself to ongoing community service and volunteer work, so I ask for your patience and understanding as I speak this evening. To introduce myself for those of you who may be unfamiliar with my story and to provide an update on the progression of the new startup I have created, Sacred Ground, I will begin by first providing a brief backstory. My name is Kelly Jo Sands Reisinger, and I reside on my family's farm between rural Hopedale and Delavan in Boynton Township, which also happens to be less than 5 minutes away from Revolution Global. My father, Douglas Sands, established Boynton Transport on our family's farm at least 50 years ago, in which we currently transport agricultural commodities, including swine and various grains. I have spent my entire life living, attending various schools, raising my family, working in and traveling throughout central Illinois. I have made it my mission in life to use my God-given privileges to become an entrepreneur, philanthropist, and missionary for the underserved, disadvantaged, and vulnerable populations within Peoria region and beyond. In doing so, my hope and purpose is to create a more culturally diverse, equitable, and inclusive environment for all who choose to embrace and nurture it. Eliminating the oppressive practices fueled and promoted by corporate greed is necessary for everyone to flourish in both rural and urban areas. For those of you who are unfamiliar with Revolution Global and why I am mentioning their organization, they are a local cannabis manufacturing facility located on the outskirts of Delavan in rural Tazewell County. Some of our ancestors, which included Daniel and Jacob Brenneman in my direct line of ancestry, were Amish Mennonite and first settled here over 150 years ago. We are now in our 7th generation of family farming. While we primarily farm corn and beans, I have been exploring new possibilities and preparing for my family to begin merging into the cannabis industry and transforming our farm in a variety of different ways. Not only were many of my ancestors Amish Mennonite and some of the first settlers here in Tazewell County, my 3 children also have Native American ancestry on their father's side of the family and who were more than likely native to this area. Along with my faith in God, this is primarily what has been driving my mission to expose the unethical and illegal business practices of renewable energy companies, which include EDP Renewables, ZEP, and Invenergy. Reform of these ordinances, policies, and practices is critical for local, statewide, national, and global protection and sustainability. Finding a healthy balance so that everyone may prosper is necessary for future generations to come. How are these companies unethical and what are they doing that is illegal, you may be asking, after I've made such a bold statement? Well, when Horizon Wind Energy which was transferred to EDPR shortly after their first project was constructed in Boynton Township to cover their tracks, came to the area around 2009 to 2011, their representatives relentlessly and unapologetically harassed my family for our farmland. They wanted it for their industrial wind turbines at the time, but we had no desire to give it up to them for any reason. It had been in our family for several generations, and we intended to keep it that way. We were again contacted last spring by one of EDPR's representatives because now they are seeking additional contracts for proposed adjacent wind turbines and to use our land for solar panels for their expansion project, Rail Splitter 2. At the time this first began happening years ago, I was living inside the village of Hopedale and could only silently observe what was traumatically unfolding before my eyes on the rural countryside I grew up on. Upon receiving a clear vision of the future in our small rural community in the summer of 2011, while everything was being constructed, I made it a mission of mine at the time to help put Hopedale and Belleville more clearly on the map because this major corporation did not deserve to have the glory over natives in this area. While I did not know at the time exactly how I was going to accomplish that, I threw myself into my nursing career and am now a high honors graduate student at Illinois State University's Mennonite College of Nursing, working as a change agent on a variety of projects to improve the quality of health care delivery for rural Americans through transformational leadership practices and cutting-edge research in the therapeutic utilization of medical cannabis. Working in advocacy and activism, my goal is to help improve the acceptability, accessibility, and affordability of medical cannabis for consumers because I believe it can ultimately save lives from opiate overdoses, suicides, and addictions to other toxic substances. At the time this began happening, however, I was struggling to make ends meet and working minimum wage paying jobs just to try and keep my 3 children and myself alive, while also preparing for a divorce from my ex-husband. At this time, I am also facing the possibility of needing to go on SSI and taking an early retirement at the age of only 45 if I'm unable to see my visions become a reality. This is because of recently surviving breast cancer and other pre-existing conditions I must manage. I had to leave the bedside as a float RN for a local hospital system upon contracting COVID-19 while taking care of infected patients during the pandemic at the end of 2021. I am currently focused on my health and recovery through ongoing therapy services because of long-term COVID-19 related complications. To better clarify their wrongdoing, my elderly and disabled grandfather, who was blind in one eye and severely hard of hearing in both ears, initially resisted the temptation to sign into their long-term contracts and take any of the settlement money being offered to him by Horizon Wind Energy. The pressure ensued, however, and my father and youngest brother eventually succeeded allowing an easement around a corner of our farmhouse property at Market and Town Hall Roads and took a small settlement offer for a wind turbine that was constructed on an adjacent neighbor's farmland. They were both reluctant to sign into these contracts, however, since American Tower already leases land in our barnyard for a cellular communications tower that was constructed around 1998. It is important to note how I have had to notify authorities about this tower because subcontractors for T-Mobile have been caught trespassing on other parts of our property without identifiable logos on their vehicles or clothing. During initial construction of the Rail Splitter 1 project, my grandfather was later approached in 2011 that he would have to sign one of their contracts and take a small settlement offer because they constructed a wind turbine too close to his farmland behind the farmhouse anyways. At the time, he was already in a stressed out state and trying to care for my elderly disabled grandmother in their home, whose condition had been deteriorating since 2006. He did not have the time, energy, or income to battle them in the court system. They told him that if he did not sign the contracts and take the small settlement being offered, then they would have to take the wind turbine down. They had just spent how much of taxpayer money putting it up? He reluctantly accepted their small settlement offer because he still had some debts to pay off before he passed away. Although he was coerced by these companies into signing their contracts, everyone was under the impression that it was only for the land behind the farmhouse. However, there is currently a wind turbine that is attached to the deed of his home, which is located on Boynton Road. This is also where I now currently reside. There are also at least 3 to 4 other wind turbines within a half mile of the home I purchased for my father after my grandfather passed away in 2019. Numerous other wind turbines are located within less than a mile of our properties. I am currently questioning the validity of the wind turbine that is attached to the deed of my home, which sits on adjacent property belonging to another farmer. I have not received any sort of compensation for these structures to operate within such close proximity to my home, nor am I willing to take anything at this point if it means being placed under a gag order. Over the past year, I have been working diligently to develop a business plan for our family's farm that will help transform our farming operations and create a more sustainable ecosystem within our region. I have been working tirelessly, in addition to surviving stage 1 breast cancer this past year, to expand my network and begin co-working more closely with Illinois State University, local public officials, the SBDC, OSF Innovation, University of Illinois Extension, enabling nonprofits and SCORE, Bradley University, Distillery Labs, and recently the Morton Chamber of Commerce. I was also recently invited to become a mentor for students at Bradley University's Turner School for Entrepreneurship and Innovation, and plan to begin mentoring students upon receiving licensing for the cannabis dispensary my team has applied for during this application window. I would also like to collaborate with other colleges, universities, and vocational training programs for students to have access to educational opportunities within multiple industries. My children and I qualify for the Social Equity Cannabis Loan Program in the state of Illinois due to my ex-husband's, their father's background and cannabis convictions from 2005 when we were still married. We have already been receiving offers for loans and assistance in securing grants based on our demographics. EDPR and the other wind and solar energy companies pose a threat to my family's security and ability to build and prosper the way we see fit on our land. We would also like to repurchase land that had previously been sold by our Brenneman ancestors if provided the opportunity. We are asking for your support to see that our family is protected from outside investors whose sole mission is to seemingly line their already deep pockets and acquire as much land for themselves as possible. While I am not entirely anti-wind and solar energy and support other landowners to use their property as they see fit for their family, I am in favor of protecting the personal rights and liberties of all landowners in this county. This includes those who choose not to participate in expansion projects by outside investors. Anyone entering into long-term contracts and taking settlement offers or payments from these companies is slapped with a gag order and prevented from telling their story to others except family members. I refuse to be silenced about this corruption and was not part of the settlements made. When I saw my home on EDPR's presentation to local county officials last spring, I felt threatened by their representatives. I never gave them permission to use my home for them to try and sell themselves to others. It was also an arm's length transaction because I purchased the home from my father after he inherited it from my grandfather. I have fears that they are willing to go to any length to get what they want, and I'm asking for your protection to keep them as far away from our properties as possible, which would be at least 1 mile or more away from our property lines in all directions. To explain more specifically the concerns I have related to the aforementioned amendments being addressed today, I will start by stating that Amendment 65 protects outside investors more than it does citizens of this county. County officials must ensure its citizens are protected over these investors who reside in other areas. The priority must be the health and welfare of all people in this county over profits to be made. The amendments to the wind farm ordinance need more careful consideration, even at the state, national, and global levels, to ensure public officials are protecting non-participating landowners who may have business expansion plans of their own. There are also still many questions being raised regarding the safety of these industrial energy generating structures and the negative impact they have on communities of people, wildlife, and the environment, both onshore and offshore. Finally, the amendments to the solar ordinance also need more careful consideration in response to the roof fire at the Olympia High School in rural Stanford, in which the entire school had to be evacuated, and students and staff are still working remotely because of smoke, fire, and water damages to the structure. Although I am unsure as to how the fire started, initial reports are that it was caused by faulty solar panels on the roof of the high school. These solar panels are on top of each grade school within the district, which many families have expressed concerns about. The 4 counties that make up the Olympia School District include Tazewell, McLean, Logan, and DeWitt, all of which EDPR is located within. Public officials at all levels of government must act swiftly to ensure the safety of our children and their families is prioritized over corporate wealth-generating tactics. Since I do not want to take up any more of your time here on the stand, and other people want to have the opportunity to speak, I invite you to see me after the meeting if you are interested in learning more about my role as CEO of Sacred Ground, VP of Boynton Transport, and my business plans to grow the future of Brenneman Enterprises and the Daniel and Jacob Brenneman Family Foundation. I have also created an idea for the Office of Holistic Health and Wellness Promotion in my Finance for Nurse Managers course last spring that I received the attention of OSF Innovation and other organizations. You may also email me at risingek29@gmail.com, connect with me on LinkedIn, or contact me via phone at 309-261-1431. I am currently in a generator program at Distillery Labs and hope to be accepted into their G-Beta Accelerator program this fall. Thank you for your time and interest in helping us to preserve and protect the integrity of Native American heritage, Tazewell County's first settlers, and rural farming families everywhere.
Okay, thank you. What's that? Does anyone have any questions? Zoning? Land use? Yes.
So we've heard your comments, and we're talking about proposed amendment number 65.
Mm-hmm.
I got a disconnect here of what your comments have to do with this proposed amendment on notification to.
Okay.
So 65, I think I addressed that in one of my paragraphs there.
Go ahead.
Okay, I was just going to say that I felt that Amendment 65 limited gave more power to outside investors so that it limited our time so that we could prepare for collecting information or contacting people that we needed to contact if there was something that we needed to do. So I felt like it was, going to give more power to people, to non-citizens or people who maybe don't live within this county.
Okay. Other questions? Land use? Okay, yes, you're excused. Thank you. Amber Towle? Okay, I'm going to ask a question. Is this on the 15 to 45 day notice? Okay, thank you. Right, and then you're going to have a separate presentation on the wind and solar, okay, because you've signed up on all of them, okay. Name and address, please.
Yes, my name is Amber Toll, 29300 Warwick Road, Mackinac, Illinois.
And do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
So my comments around 2329A is the notice to the public is only required to be 15 days. I believe this is inadequate. The county board recently agreed to 45 days, but to maintain compliance with the state, I would like to see something more reasonable than 15 days, such as 35 or 40-day notice. By changing one word for no more than 45 days, we went from giving the public a 45-day notice to only requiring a 15-day notice. It's my understanding that the posting goes out on the newspaper of general circulation in the county, I believe to be the Pekin Times. Notifications are also sent by mail to adjacent property owners. I would like to propose notifying all property owners within a 1-mile radius of a project for wind and looking to similar considerations for solar. Notification by mail, it's harder to judge without going certified, so I believe simply adjusting the wording so that we are postmarked not less than 40 days or no more than 45 days notice to all residents within 1 mile of the project footprint would be reasonable. Also, in the mailer, it would be nice if there was a reference to where additional information can be found, such as posting on the website, which brings me to the next point. Tazewell County maintains a website. It would be beneficial to the citizens for the posting to be made available on the website. Also in advance, it would be simple to post it within 40 to 45 days notice prior to the hearing on the website. It is my opinion that notifying our rural communities of an industrial scale wind or solar project in rural Tazewell County is not best just in the Pekin time. I believe going to the website and doing mailers would help spread the word more efficiently. Personally, I do not see where this would be limiting, and having a 5-day window would not fall entirely on any weekend, and we would know what day the paper is published, or if we make improvements, we can control what date is publicized on the website. The state limited the ability for the county to provide additional notice to the public. However, we can hold the developers accountable to transparency. One suggestion would be providing at least 90 days prior to submission of an application. The applicant may make reasonable efforts to inform members of the public of the proposed project. Mailings and notices of public community meetings or open houses shall be sent to all landowners and residents within the footprint and to all landowners and residents within 1.5 miles of the proposed outside boundary of the project. In closing, I believe that under the new state act, still allowing 40 days notice is reasonable. In fact, we need public participation at ZBA. That's why we're all here. This is important because citizens have the right and responsibility to be aware of ZBA cases and to have the opportunity to take advantage of the process. We know, because of the board, just a couple months ago voted to increase the notice to the public for projects of this scale, that preparation time for these projects, whether it's hiring an attorney, reviewing the application, or having an independent study done, takes time. I understand this requires a little extra effort to attention to detail by staff, but I have confidence in your ability. It's a little thing that may make a big difference to the permanent impact of these projects have on residents' lives on adjacent properties. Thank you.
Okay, some clarification. So on paragraph 157.482, notice to adjoining property owners, your suggestion is rather than adjoining property, it would be all property owners within a 1 mile radius?
Yes. And to add a little detail to why I feel that's important is, for instance, we have one farm where we own the farm. It's on 4 sides of a homeowner. And if we decide not to sign up for a project, we own every adjacent property line to that family. They would not receive.
Explain the situation again. I haven't got it pictured in my mind.
So if a wind project were to come to Tazewell County and my family decided not to sign up for the project, we would not be an adjoining parcel. If we own all 4 sides to a family's home, that family would never be notified of the project because none of their adjacent 4 property lines would be a participating parcel.
And the home is not on the adjoining farm ground?
No, it's a different family.
Okay. And then, so at number 2, you're saying 40 days notice, but isn't that included in these timelines? It says not less than 15 and no more than 45. You want it to be a specific 40 days only?
I would like to see the minimum increased. I do not feel that not less than 15 is adequate time. I have confidence that good faith we would shoot for more, but I would like to see it required.
Okay,
I couldn't hear that. Can you say, what's your new, not less than how many days? It was 15?
Yes, I would like to see a longer update, such as 35 or 40 days.
okay. Do either one of you have any input onto that as how it relates to the act and what the act specifically states?
The act says that the public hearing must be held within 45 days of the application being filed. So I would think if you wanted to do 35 to 45 or something like that, I don't think that would be prohibited by the act.
Okay. Board members, questions? Land use? Yes.
So Amber, I've got, I'm just recapping real quickly your 2 requests. One is that the not less than 15 be not less than And if I add you to what the attorney said, maybe 35 to 45 days. And then the other one is rather than the current,
Ours says adjoining.
the current adjoining, that it would be all property owners would be noticed within a 1 mile radius.
Yes.
That would be work for the group.
Of the outside boundary of the project.
Oh, one side, 1 mile radius of the outside
Yes.
boundary.
And all within the footprint.
That's all I have, Mr. Chairman.
Okay, so was that just added, all your comments of all within the footprint? I don't see that on this paper you gave us.
I maybe wouldn't.
Landowners, oh, within the footprint. Okay.
Thank you.
Okay. Other questions? Land use or zoning? Yes.
So just to clarify in my mind, this notification is strictly for renewable energy, or is this for everything that we do?
It's for everything that we do. We had previously tacked on at the end of each of those sections a minimum 45-day provision for renewable energy. That's what's being stricken because the new act says we can't do that.
But this will affect everything that we do for the zoning board for all special use permits, for notifications that go out to property owners, adjacent property owners.
Or Class A requests.
So that Class A requests are commercial wind farms, commercial solar farms, and adult use.
Commercial farms, commercial solar farms, and adult use, right?
Commercial wind farms, commercial solar farms, and adult uses. Yes, sir. Okay, then, Jackie, do you want to address the website suggestion she had, or we have various stuff up on the website? And then I'm going to have the attorney's address as to whether that can serve as a legal notice.
So I don't see any problem adding more information to the website if that's the request. We would do it in the same fashion that we do everything now. The only, it would be an internal change and take a lot of modification given I'm just speaking to your other, the notification. Our dates are all set for our meetings annually. We may run into an issue with trying to have different filing deadlines and scheduling meetings differently. That's why we were okay with going to the more than 45 days, because we would still hit the same filing deadlines, and then we would kick it not to the next meeting, but the meeting following. So that seemed reasonable to do. This would be treated completely different if we were to do that, but I don't see a problem with the other items, more information on the website, requesting that, the developer does more public outreach in advance, something like that.
Okay. May I clarify one thing? When I was doing the website, I was initially thinking just the Class A, like the one just like you did last year for the special zoning case. I wasn't intending for every single zoning case to have to change. So.
Okay, so I'm going to clarify this for the board, what you said. Her notes here for 2329A, it refers to Class A zoning cases.
Yes.
which are none of the cases that come before ZBA, with the exception of adult use, commercial zone, commercial wind farms, and commercial solar, right?
They all come before ZBA, but Class A can only be approved by the county board.
That's another true thing about Class
Yeah, but I thought you said they won't come before zoning. I think he said that the only,
A. These provisions that Todd was talking about.
okay,
The zoning administrator said, I just want to get clarification, I'm not arguing.
Right.
The zoning administrator said that if, when Todd said, will this be all cases then that come before ZBA? She said, no, only Class A cases, which are made up of those three things.
correct. Okay. Can website notices be used as publication notices? I don't think you could replace newspaper-based notices with notices on the website, but it could certainly be a useful supplement. There's nothing that forbids it. Okay. And so, Jackie, why don't you explain the procedure to us if you had to identify all property within 1.5 miles and all residences within 1.5 miles of a footprint. The way I understood her, that the total footprint of a wind project.
So if we notified by mail everyone within the footprint and within 1.5 miles the boundary of any footprint, that's just going to be significantly more mailings.
How do you identify?
So right now, if it's just a project, so you have specific sites, then we are able with GIS to identify anybody with an adjacent, or excuse me, a touching boundary, whether it's across the street or immediately adjacent. So if this were the case, we would just set the perimeter of the footprint within 1.5 miles, and then notification or mailings would be sent to all of those individuals. I don't understand that correct.
Okay. Other questions? Land use, zoning? Okay.
So in case of 1.5 miles, go back to the cases that we dealt with Tuesday night, you would have been north of 474 in East Peoria. You would have had to notify literally thousands of people.
I was suggesting 1 mile for wind and a similar consideration for solar. It may not be 1 mile for solar.
But even with 1 mile,
In that
in
situation.
that situation, it would have been a whole bunch of people you would have had to notify.
Okay. Yes.
Yeah, when you refer to mile or 1 mile, when we talk about wind, are you talking about the total boundary area, just so it's clear in my head, or looking at each site individually? Total footprint?
So I'm thinking if you have like the outline of the footprint, it would be 1 mile from the outside boundary.
So everyone within, and then 1 mile outside of that perimeter.
Yes.
I guess when you say the footprint, are you suggesting all the properties that are involved? You're not suggesting these identify where each tower is going to be and then.
So yes, it would be all the properties involved, which would also include the turbines that are
Sure.
built.
Right.
Yes.
Yes, question?
With regards to the timing, I don't know what papers we actually publish in. Do we publish only in daily papers, or are there some that are weekly or monthly?
Currently, we publish only in the Tazewell Chronicle.
So that my concern was if we went with between 40 and 45 days, would we actually have no paper being published in that period, so that we couldn't possibly do it, but it sounds like it might be workable.
Okay, other questions? Okay, closing comments?
I guess I already gave my closing comments.
Okay.
Thank you for your consideration.
Okay, thank you. Okay, board members or land use, any other questions concerning notice to the public, notice to adjoining property owners, or notice to interested government bodies? Yes. It was crossed out. Did it get crossed out? Okay. Joyce Blumenshine, did you want to speak to the notice? Okay. Yes.
I just wanted to speak to what you just asked before you talked to Joyce. I made a rough comment, but it wasn't on the record, so I want to put it on the record. And that is, we talked about how sometimes within that additional due diligence for notification, sometimes it means there's quite a number of households or residents that end up being communicated with. And, maybe that could drive the cost or something. I think that's a relatively minor issue with regards to this in terms of communication to people that have a major impact on their life. But the other thing I'll point out is, and we learned this in spades 48 hours ago, both the members of the county and the ZBA, that what drives that increased cost is increased numbers or density of residents. And that's the very thing that I and others preached 2 nights ago that should prohibit that location from being considered in the first place. Thank you.
Okay. Okay. We're going to put that back in your file, or where we keep that. Okay, our next case is 23-30A, petitioner Tazewell County, proposed amendment wind energy ordinance. Health Department, Soil and Water made no comment. Tazewell County Farm Bureau had no issue. Tazewell County Highway Department had no issue. And Tazewell County Farm Bureau had no comment. And John Oliphant, the city of Washington, supports the proposed changes. Okay, and so we're not necessarily going to go through this line by line unless we need to, and we will. If there's specific areas that, as an example, the previous person wanted to address specific things and gave us examples of suggested changes and so forth. That's what we're looking for. And so be mindful that the discussion needs to pertain to the code. That's what's on the agenda tonight, is the new updated code for, we'll do wind first and then we'll do solar second for Tazewell County. Would either one of you 2 attorneys want to give an overview of this?
Briefly, the purpose of this amendment, well, back up a little bit. In late January, the state legislature passed an act that limited county's abilities to regulate the siting and installation of wind farms and solar farms. The purpose of these amendments, 31 and 32, or I'm sorry, 30A and 31A, is to bring our ordinance into conformity with that statute. The statute provides that if we don't bring our ordinance into conformity by late May, that we may lose the ability to place any limits on the placement of solar and wind facilities. And we may lose any abilities to impose restrictions that I think we'd all agree are reasonable, such as setbacks and that sort of thing. So it's imperative that we take some steps to bring our ordinance into line with the act. Just hit some of the highlights. The act imposes maximum setbacks that can be required for wind towers. It imposes limits on, it basically eliminates our ability to restrict the height of wind towers, saying only that we can require them to be compliant with FAA regulations, which is something the developers would have to do anyway. It specifies that any road use agreements that are entered into must be reasonably related to the construction of the wind farms, that developers are allowed to impact drainage facilities and drainage structures if they repair them afterwards. And it requires the developers to enter into agricultural impact mitigation agreements with the state, which include a decommissioning plan, and we are not allowed to tighten up decommissioning requirements much beyond what's in that plan. So this amendment changes our ordinance to follow those new requirements. And, just make sure I'm not missing anything here. Yes, a couple important things I did miss. We're allowed to require that developers limit shadow flicker on non-participating residences or occupied community buildings to be not more than 30 hours a year. We can't impose a restriction that is tighter than that. So essentially, the state law is saying that non-participating residences or occupied community buildings are going to be required to accept up to 30 hours a year of shadow flicker from wind turbines. Furthermore, we can impose restrictions on the noise generated by these facilities, but they have to comply with regulations that are already in place by the Illinois Pollution Control Board. We can't make our restrictions any tighter than that. And we can require developers to provide various reports, to consult with various state agencies like the Department of Natural Resources, the Nature Preserve Commission, U.S. Fish and Wildlife, and the State Historical Preservation Office. So that's a brief summary of what the state's requiring us to do and what we're trying to do with this amendment.
Okay, thank you.
Ask questions of the attorney.
Yes, board members first. Zoning board members, questions, thoughts on the wind portion of the code? Yes.
I know Matt had said in here that the FFA or FAA sets the height, maximum height. Do we have any idea what that is in Tattle County, or does it vary from location to location?
It does vary from location to location. I did my best to understand it. and I don't fully understand it, but I can summarize it as saying that the closer you get to an airport, the shorter they have to be. And there's these imaginary lines that they think about that kind of proceed up and out from the runways of the airport, where, you know, as that line goes up, the height of the tower can go up. But essentially, if you get, I think it's, maybe Alec can speak to this a little bit, but I think if you get up to 3 miles from an airport, there's some distance that I believe is about 3 miles where there's no height restriction imposed by the FAA.
And is that for all airports, or is that just for like Peoria, Pekin? There are airfields around the county. I know there's one in Minear, and I think there's one down on Manitou Blacktop that crop dusters use. So do those figure into that also? Do we know?
That is a good question that I don't know the answer to. Mr. Messina, do you have any input on that?
That is a really good question. Let me take a look at the language really quickly, but I'll follow up with you either this evening or tomorrow.
Well, the other part, I think, of your question is, then the height limit becomes dependent on the size of the property and the placement, because it has to be 1.10 or 1 point away from boundaries, houses, community buildings.
Exactly. If the FAA is saying the height to the top of the tip of the blade can only be 400 feet, then we're talking, what, 440 feet from the property line that it has to be, or the adjacent property line. If they're saying it could be 600 feet, then that's 660 feet away from the property line.
Right, and so depending on whether it's a narrow, long 40 acres,
exactly,
you're not going to be able to place it, whereas, 660 feet to 1/4 mile. And so either they can't use that site because of the boundary limitations, or it has to be a shorter tower.
Yeah.
Okay, board members, other questions? Land use? Yes.
This is
A little closer to the mic.
you can't hear me, right? Okay, is this okay?
Yes.
So, I don't know who this is for, but probably either Alec or Matt. And I guess I should start it by saying, Mr. Messina, the last couple of times that we've talked in Springfield, I've sort of asked this a couple of different ways, and the question was, what happens to us if somebody in Springfield, my college buddy, Don, the Democrat president of the Senate, or somebody else like that, decides that we have been more restrictive than they allowed? I've heard you answer that a couple of times, and every time I hear you answer it, it's, I don't know. Is that correct? And has there been any more or additional clarification as to what happens? Before you answer, let me preface. I think, I can't speak to other counties, but I can speak to Tazewell. In Tazewell County, there's no board members, probably no ZBA members, that want to wave a red flag at the state. We do want to have proper zoning, and we do want to protect our citizens. And we want to protect it to the extent that the law allows and makes sense and consistent with our ordinance and our zoning code. And regardless of what we think about what Springfield did, we want to play in that area. On the other hand, we don't. If we are either going to get this spot on perfect, which you know what the chances of that are, or we're going to err. And where I'm going with this is, if we're gonna err, which side do we err on? Do we err on the side that we worry about some bureaucrat in a land use department in the state of Illinois that doesn't exist unless you got some sub-director at ag? And I've been working full-time in Springfield, doing this. Do we worry about that? Or do we worry more about the other way, which is protecting the citizens and the agricultural community in our county? So if you have any additional insight, because I know you're there all the time and you're listening all the time, and things change in Springfield, we all know that. So if you can give us any additional insight about what happens to us if somebody thinks we've been too egregious, I would love to know that, because that's going to give us a little bit of indication if we have to err, which side we err on. Thanks.
I know you enjoyed putting words in my mouth, given the last 2 times we've met, but no, so no, I don't think I would agree with the premise that we don't know. I mean, I think there are definitely unanswered questions, and I think that when we did discuss, and I would still say that today, I will say it today, and that is that erring on either side of the equation certainly opens up the county to liability in whatever form that comes in, whether it's a legal challenge from a developer or a legal challenge from some other entity that, you know, we haven't identified yet. But in terms of, so I think there definitely is risk to the county there, and risk to the county in being able to enforce the ordinance, whatever ordinance it has in place. And then it sounded like there were a few different questions in there. So I was trying to keep track, but I mean, I think also, you know, when all of the elected officials that are kind of weighing these options, and it is complicated, but I mean, I think you have to err as best you can in complying with the law, right? That ultimately is what's going to be decided, and a good chunk of the law. And there are some items that certainly you can talk through a little bit, and in any ordinance or state statute, you know, there is some opening to, they are open to interpretation for sure. But I would also say that there's a lot of specificity here as well.
Well, there's 102 counties, and there's going to be some variation, isn't there? And so the state's going to have a few things that go on their radar. I can't believe, I still can't believe, having lived for as long as I have in government and politics and law as long as I have, that so most of it is not going to be settled in court cases. But rather than some statutory authority, or rather than some administrative authority coming out of Springfield. But nobody, I remember my preface, nobody intends to err. We want to get it straight. We don't want to be the poster boy for a court case and spend money so other people learn from our lessons. We don't want that. We want to learn from somebody else's lessons. It's cheaper that way. But it just goes without saying that this is so fuzzy, this whole damn thing, that somebody's going to be a little off of perfect. Okay? And so I just was looking for, if we end up not on purpose being off of perfect, like for example, I'll give you a perfect example of the confusion right now. You pointed out, Eric, excuse me, when we were in Springfield, that one of the things we should, Caswell and I could go to school on, is those areas where the state public act was more silent, rather than on those obvious, clear-cut, easy to understand restrictions. And one of those was the management of the entity, and another one was the road use agreements, and another one was decommissioning. Tonight, for the first time in my life, I've heard Matt say, oh no, decommissioning is very clear from the state what we can and can't do. That's totally 180% contrary to everything I've heard about decommissioning prior to this. So, I mean, I guess, either people are misinterpreting or people are changing their interpretation or the communication about the interpretation is being changed. But it makes it very difficult to spot on hit exactly what we're supposed to do as a county.
So, again, a number of things there, and I think I would respectfully disagree with part of the premise, because I do think that the statute in many respects, in most respects, in fact, is not fuzzy. I think it's pretty clear. I would agree that you know, and this is kind of just a common principle, you know, when you're looking at these things, whether it's a federal regulation, the state's looking to involve themselves in that regulation, or in this instance, we have essentially state regulation, the counties are looking at it. You know, the state has kind of, you know, filled the field, if you will, occupied the space in so many different regards in this legislation that I think that it is this public act, sorry. And so I think in those instances where it is very clear, your obligations are very clear. In those instances where it is silent, which there are very few of those, it's a challenge to find them, quite honestly, then there is an opportunity. One of the things that you and I have talked about before is this third category, and that is, you know, those areas where it, you know, there might be a little bit of wiggle room in terms of interpretation. And I think the road use agreement language is one of those areas that there is a, you know, not a lot. I want to be really clear. You know, I think I've said this before, and people hear what they want to hear. And so they presume that there's more flexibility than I think there really is. And I understand that. But there is a little bit of wiggle room on the road use agreement piece, and maybe even kind of the process itself, the timing of when the county takes an application and moves forward. But as to the remediation, you know, we'd have to revisit our conversation. I think, you know, kind of in preparation for today, you know, I spent some time taking a look at the agricultural mitigation agreements that are put out by the Department of Agriculture. And they are for not just for wind farms and solar pipelines, other activities. Well, they're pretty thorough. So, you know, which I think is why the state decided to use that as basically the template for every county. So again, why answer your question in 10 words when I can do it in 100? So I apologize for kind of going on here, but I think most of this statute is pretty clear, and you would be challenged to find a whole lot of silence or gray in this public act.
Thank you, yes.
Okay. Anything to add, Matt? Well, I just did want to speak briefly to the decommissioning issue, if you'd like a little more info on that. So the code allows us, the statute allows us, and actually does require developers to enter in this agricultural impact mitigation agreement with the Department of Agriculture, the state level department. And there are provisions on decommissioning state. I don't want to read all of it, but I'll briefly summarize that deconstruction of the facility will include removal of, and then, you know, it lists all the things that have to be removed. Foundations up to a depth of 5 feet, transformers, overhead collection systems, and so on. The owner has to complete deconstruction within 18 months of the end of useful life. When they're getting the permit, they have to file a decommissioning plan. And then they have to file a second plan by the 10th anniversary of their beginning operation. They have to provide financial assurance, which is phased in over the first 11 years of operation. So when they first, on their 1-year anniversary of operation, they have to cover 10% of the estimated decommissioning cost. By their 6th anniversary of operation, they have to cover 50%, and then by the 11th anniversary of operation, they have to cover 100% of the decommissioning costs. And we're allowed to reevaluate those estimates beginning the 10th anniversary and then every 5 years thereafter.
Well, last question, Matt, for you is, Could we be, maybe for Jackie or Matt,
Microphone.
on
Microphone.
can we rest assured that the language currently in 2230A that is proposed here, if we don't make changes in it, have been reviewed by the state attorney's office for concurrence with the Public Act? So that you already screen out or modified any kind of variation that would be different from what you guys feel the state would not allow.
Well,
So the only thing, if that's true, the only thing we have to worry about is if we modify this, that we make sure those modifications also are within that thing. That's what I'm going.
I think, while I'm looking at this, Jackie wants to chime in on that one.
So what's included there is a little more, if you want to use the word restrictive, the evaluation of, that starts a little bit sooner. We don't wait until the 10th year. That language was put in there because that's what the county was comfortable with on the solar farms that are going up right now. Alec and I did speak to that because that was one of my questions, knowing what the AMA included, that it did seem that that was a little tighter. I guess I don't want to say more restrictive. And we talked about how there could be some flexibility there. Now, if a developer came in and said, we feel that it's more restrictive, then we would fall back to, if this is accepted, then we would revert back to the AMA.
So all I have to add to that is much of this language is taken directly out of the standard impact mitigation agreement that they all have to sign. Other than the parts that Jackie just addressed, it looked like. So if you did want to make changes to this, I would encourage you to be mindful of that. And of course, you could also, instead of including the language in here, refer by reference to the, or include the mitigation agreement template by reference, and do it that way if you'd like.
Thank you very much.
Yes.
So under our amendments to the code, it talks about road permits and those kind of things. So if a wind or turbine is damaged in some way, or blade fails or storm damage or whatever, the company has to come back in to get a new road permit before they can bring any equipment back in. They have to file a plan to do all that.
So there's language in here that will tie the ordinance to the road use agreement. The road use agreement, like we discussed yesterday, 2 days ago, is a separate document that's approved by the Transportation Committee and also the county board. Dan and I work closely on the language that's in here. And then, correct me if I'm wrong, Dan, our highway engineer, is here to speak to any of this information. But that language will be included in the road use agreement that is approved before any permits are issued.
Okay, so once a permit's approved for the initial construction, once construction is done and that permit goes away, any other further maintenance work or repair work, they have to have a new road permit. The road permit's not for the life of the project for the 30 plus years that the windmill's going to be there, right?
Because Dan has more thoroughly reviewed the road use agreements that he's happy with and created a template, I'll let him speak to that.
I would say that the initial permit would only be for the construction.
Okay, other questions? Land use? Yes.
So in regards to decommissioning, who's in charge of monitoring that? Like say there's a windmill that, or a turbine that's not being, this electricity is not generating electricity for 12 months. does the landowner come to the county board or the ZBA and say, look, this thing isn't doing anything, or I'm not noticing it moving? Like, who's in charge of monitoring that and making sure that it's actually gonna be used, it's gonna be fixed, or it's gonna be decommissioned properly?
So the development office, it's my understanding, will maintain a list of, they have contact information for whoever is operating the facility. And in addition, some of the facilities post that information, and there's been discussion about that at previous meetings about posting that contact information for people who are, near these things that see that there's a problem, they can get a hold of somebody to fix it. As far as a turbine that isn't like an individual turbine that's not generating any power for a long period of time, I think it's kind of hard to picture that situation arising because the operators have a big interest in these things generating as much electricity as possible. So they're able to monitor the operation of the turbines from various centers they have throughout the US and detect problems, and they would be under a maintenance agreement with the county to have somebody available to come out and fix that, and it would be in their financial interest to do that very quickly.
And do you want to comment any on the monthly reports you get from the wind companies, or that's different? Okay. Okay, other questions? Board members, land use? Okay, we're going to start public testimony on 2330A, proposed wind amendment energy ordinance. Amber? Okay, I'm going to have you give your name and address again, and I'm going to remind you you've already been sworn in from the first time. So, okay?
My name is Amber Toll, 29300 Ward Road, Mackinac, Illinois.
Okay, continue.
Over the past 2 years, almost 2 years, I've spent a considerable amount of time researching all aspects of wind energy, among which I've done a lot of research on ordinances, and I've read the state statute. The ideas that I wish to present to you today are not with the intention of being more restrictive, but are with the idea of being compliant with the state, yet providing protection to those who live within the footprint of an industrial wind energy plant, promote long-term growth in Tazewell County, and finally, not overlook items in which would inhibit growth and advancement of agriculture in rural communities. I realize I will be pointing out some of the negatives and the what ifs, but bear in mind these are large projects that affect a large portion of the county and hundreds of people. It is not more restrictive to be safe and to consider the risk associated with industrial wind. There is no shortage of representation of wind companies to present the positive side. Citizens must speak up to request the protections that we feel are important to us. We cannot count on someone else to do so. I hope that you find that my suggestions to provide more security, more safety, and more accountability for industrial wind projects. A new project such as wind or solar should not put any additional burden on the county. Nothing I am suggesting today is intended to conflict with the state act or be considered more restrictive, but I trust you'll let me know if it is. I've tried to provide the sheet in order of the ordinance as it's written, so I'll do my best to go through as organized as possible. So for definition, I've shared a couple definitions, additional definitions that I felt could be added to add some clarity in the event that any questions come up in the future. I believe there's no harm in additional detail. The county staff and board members, as well as citizens and developers, will know exactly what to expect and limit any surprises that may arise.
Excuse me, you have one more copy of this.
I'm very sorry, I don't. I double checked. Thank you.
Okay. Now let's continue.
So those definitions are substation, non-functioning wind turbine. I'll come back to a substation in a minute. Non-functioning wind turbine, a wind turbine or component that is not able to generate electricity for 6 continuous months. The county addresses facility abandonment, but there's no clarity around a single turbine that's not functioning. Existing and occupied residence, I would like to see a definition provided, as well as standard operating conditions. And I'll touch on those more as I go through those. Public power participation. I would like the purpose notifying all property owners within a 1-mile radius of the project for wind postmark not less than 40 days prior to the hearing. I've already talked about this, so I'm going to skip over it, but you do have it for your record. Special use requirements. I would like to see the LaSalle Sinclair factors added to this ordinance. I've heard that hands are tied at the county, that they must approve a wind project if it meets the state guidelines, but I want to be clear and remind you that there are other conditions to be met, and they're spelled out in these guidelines. The state statute says conditions imposed under any must meet Public Act 102-1123 and conditions imposed under any other state and federal statutes and regulations in addition to those specified herein. The LaSalle collectors would read as follows. The establishment, maintenance, or operation of commercial wind energy facilities will not be determined to or endanger public health, safety, morals, comfort, or general welfare. The commercial wind energy facility will not be injurious to those injurious to uses and enjoyment of the property in the immediate vicinity of the purposes already permitted, nor sustainably diminish or impair property values of surrounding properties. The establishment of the commercial wind energy facility will not impede the normal and orderly development and improvement of the surrounding properties. Adequate public utilities, access roads, drainage, and necessary facilities have been or will be provided. Adequate measures have been or will be taken to provide ingress and egress so designed as to minimize traffic congestion in the public streets. The proposed commercial wind energy facility will not, contrary to the objectives of current comprehensive plan of the county. The commercial wind energy facility shall, in all other respects, conform to the applicable regulations of this ordinance in the zoning district in which it is located, except as such regulations may, in each instance, be modified pursuant to the recommendations of and approved by the county board. I would also like to see in writing the time limit for acquiring a building permits. For projects of this scale, perhaps a time limit of 2 years is reasonable. I feel this is important because, for example, in Ford County, a project went through ZBA back in 2008, but the project was not built until 2021. I want you to think about how technology has changed in 13 years. What kind of cell phone did you have in 2008? These turbine technologies are going to change as well. They should come in front of the ZBA again. On to the next section, design and installation. Colors, towers, blades. I would also like to see included that there may be no visible advertisements on blades or towers. Lighting. A lighting plan for each commercial wind energy facility and substation shall be approved by the Zoning Board of Appeals, including description of all lighting that will be used, including any lighting that may be required by FAA, the plan number and location of lights, light color, and where the lights will be flashing. I would like to see strobe lights discouraged unless they are required by FAA, then they must be shielded from the ground. Items that can help reduce visual impact are synchronized lighting, shielding angle of the light, and reducing glare. A section that I would like to see added is FAA obstruction marking and lighting requirements. I would like to add aircraft detection lighting system or comparable technology suitable to meeting FAA requirements, marking and lighting FAA obstruction marking and lighting requirements. This future advancement shall warrant new installation of equipment to lessen environmental light pollution and visual nocturnal disturbances. This is becoming standard. There are existing projects with such systems that are approved by FAA. This is not restrictive, but it does minimize the impact of lights on the public. I would also like to see some language around lighting for substations. This is why I had the definition added for substations. Currently, there's no guidelines for the light emitted from a substation. We have the technology and light fixtures available to minimize light pollution protruding past property lines. It's not as common to see it in rural ordinances, but in more of the cities you see where they'll say no light from a substation shall emit more than 0-foot candles of light beyond the property line. The lighting should be planned and developed in such a way to minimize visual impact of the structures. As for the red flashing lights, I would just like to point out that they are not all created equal. I'm not aware of all of the specific options that are available today, but if an application were in front of you, I think it's an important item to consider. These flashing lights can be seen for a long ways, over 25 miles. An example that you guys could observe and go out and observe in Tazewell County today, for example, would be Rail Splitter 1 turbines. They have a flashing red light, and if you look further south, for instance, I can see it from the winery very clearly up on the hill. You see that the next wind turbines down in Logan County. Rail Splitter 1 is a nice slow flash. They're older lights, they're not LED. The new ones, they're more of a harsh flash. I think it's important to consider which one would be less harsh to the residents living among them, and we could have a say in that at the hearing. Under warnings, in addition to what's already proposed, I think the sign should include the 911 address and an emergency phone number of the facility owner, which shall be answered 24 hours a day by a live operator for emergencies. A non-emergency phone number for the facility owner shall also be displayed. These phone numbers shall remain active, with all calls being voice recorded for verification purposes and with comments and complaints logged and reported to the county. It is noted in 15308 how to handle complaints, so no additional comments there. Under setbacks, I had a question around what the process looks like if these are changed at the state level. I know there is a trailer bill out there, so I was just wanting to learn more about what the process would be if they're changed, and how the county would conform to that. Drainage tile. This section is detailed to include construction and decommissioning, but it fails to mention anything about maintenance. Damage done to tile at any time during the life of the project should be subject to repair and remediation by the facility owner. These towers will require maintenance over their life, there's no doubt. The cranes and equipment brought in are heavy. Most of your lateral tiles are at a depth of about 3 foot, and compaction of these cranes will reach that and it will crush that tile. Even if there's no digging or no transmission lines going through it, simply driving over it with their heavy equipment can cause damage. I think it's important that we either include drainage tile over the life of the project or add in maintenance in our definitions. Compensation for crop loss due to tile failure during construction, maintenance, and decommissioning, again, over the life of the project. Tile is very valuable to our farmland and operations, and in the right year, it can have a huge financial value for the farmers. Also, I think it's important to note that tile lines cross property lines. The tile in one field is often the outlet tile for another field. The compensation should look beyond the property where it's located and look to the entirety of the drainage system that was affected. Turbine locations, this is another added suggestion. No turbines or substations shall be moved more than 50 feet in any direction from the location set forth in the special use application. This one's pretty self-explanatory. I come to ask you if I'd like to build a house to get some permission, special use on that, and then I decide to move it a quarter mile down the road, I would have to repeat the process to get a special use permit. This is important for turbines because the location of the turbine at the ZBA hearing is the base for all studies, such as the shadow flicker analysis, the sound studies, drainage district, or soil sample analysis. Operations and maintenance. I'd like to see some language added, such as any physical modifications to the towers that alters the mechanical load path, or major electrical components shall require reapplication for the special use under this ordinance. Like-kind replacement shall not require recertification prior to making any physical modifications other than like-kind replacements. The owner or operator shall confer with an independent third-party certified engineer and provide that information to the county to assist in determining whether the physical modification requires reapplication. This should be the decision of the county board. This provides additional accountability and keeps the county informed of any major changes that may occur. The annual inspection report. This is something that's required and the ordinance is drafted, but I believe it would be in the best interest of the county for that annual inspection report to be submitted to the county annually and retained also by the county, not just by the wind company. Additionally, each commercial wind energy facility shall be required to have the facility inspected by an independent certified inspector at the completion of the construction of the project to verify compliance with the zoning regulations, including all applicable codes and requirements for commercial wind energy facilities. Furthermore, the facility shall be inspected annually for 3 years following construction to verify continued compliance with zoning regulations. Finally, inspections shall be performed at least every 3 years for the life of the project. Inspections necessitated by complaints or otherwise shall not replace annual or triennial inspection requirements. The reason I believe that these inspections should be submitted to the county, the annual inspection report, is that the event that the project does happen to go bankrupt or the companies become unreachable, these could be useful documents to have access to. We're requiring to do them, so we might as well get a copy of them. It's also happened before where a wind turbine was not built exactly where it was supposed to be. I just learned of Kelly's experience tonight. Even if we believe that the companies that we're working with today to be 100% truthful and to make no errors, this ordinance is for more than just the companies that are in the county today. And it shouldn't be a problem for them. I hope it's not another 15 years before we address an ordinance, but we can't predict the future, so we must be cautious. I also think it's important for them to have inspections post-operation, because at the time of the application, a company can demonstrate that they will be compliant and within limits on paper. Obviously, the turbines are not built yet. This is done through modeling. Once they're up, I believe we should hold them accountable. We should check it in real life and make sure they are still compliant. As far as the multiple testing, I think about how often other special use requirements are tested, such as the landfill, to ensure that it's compliant. I'd be shocked if you told me that it was passed years ago and has been never looked at since. Another example would be the septic testing. There is routine maintenance or routine inspections to ensure compliance. I would also like to see taken into consideration that all modeling and testing is completed in all seasons. This would include sound and shadow flicker. We should test it when the ground is frozen, but also when it is soft. It will make a difference. Interference. I would like to see this section looked at to provide more protections to the citizens who will be living within these projects. Currently, only addressing severe interference seems a bit extreme to me and inadequate. Some language I suggest would be, prior to construction of any turbines, the owner or operator shall conduct a study to establish the baseline status for all. There's a list of different interferences in the area of the turbine, with copies of the study be supplied to the county. The applicant shall provide the testing and the applicant shall provide evidence that any potential interference has been resolved to the satisfaction of the providers. I think I butchered reading that, but that's why I printed it for you. If after construction of the WEX, the county receives a written complaint related to any of the above mentioned interferences, the county shall have the right to investigate and enforce mitigation of the complaint. Shadow flicker. So this goes back to the definition of planned operating conditions. Under state guidelines, non-participating residents must endure 30 hours of shadow flicker under planned operating conditions. I would like to see that defined. Such as planned operating conditions are defined as those conditions that would exist if the sun were to shine with limited cloud cover. What is the method of remedy if the actual amount of shadow flicker exceeds the limit of 30 hours? What if the computer modeling says it's going to be 30 hours, but in reality, it turns out to be 70 hours or worse? Speaking of computer modeling, at the time of application, I believe it to be a normal requirement for a company to conduct and submit an analysis on the potential shadow flicker of adjacent properties, which I don't see a requirement for that here. Under noise levels, I have questions around how the county is going to ensure and enforce that the wind energy facility is in compliance with the Illinois Pollution Control Board regulations. To demonstrate that the wind energy facility is in compliance with the Illinois Pollution Control Board regulation, additional language could, and I believe it should, be added. The applicant, through the use of qualified professional as part of the siting approval application process shall appropriately demonstrate compliance with the noise requirements of the siting section and provide contour maps in intervals of no greater than 5 feet. Sound pressure levels shall be measured using the measurement procedure set forth in the Illinois Pollution Control Board regulations, except that sound pressure levels for purposes of establishing a violation of this section may be measured at any point on the residential use property for agricultural property, not more than 150 feet from any portion of the edge of the primary structure. No portion of the property shall exceed the noise level set by the Illinois Pollution Control Board. No portion of the property shall, to the extent any property has multiple uses or classification, all the land utilized for a particular use must not exceed the Illinois Pollution Control Board noise regulations for the classification of use. The owner of the receiving land may waive compliance with local measuring points requirements pertaining to the Illinois Pollution Control Board regulations for the owner's property. In addition, at least every 24 months, the county shall hire a qualified acoustician to conduct testing at the at most risk residential properties and agricultural properties to ensure ongoing compliance with the Illinois Pollution Control Board. The cost to conduct these testing should be at the expense of the facility owner. If at any time throughout the life of the project the noise levels are found to be not in compliance, the applicant or facility owner will immediately shut off all turbines until the county approves a solution after a hearing at the ZBA. I think it's important to note that the noise levels must comply with the Illinois Pollution Control Board at all times, all seasons, all wind speeds, at all times. The following is a series of sections that were not present that I think could be added. And they're materials handling, storage, and disposal. All solid waste related to the construction, operation, and maintenance of WEX shall be removed from the site promptly and disposed of in accordance with federal, state, and local laws at the expense of the owner-operator. All hazardous materials related to the construction, operation, and maintenance of WEX shall be handled, stored, transported, and disposed of in accordance with all federal, state, and local laws at the expense of the owner-operator. I think that one's also pretty self-explanatory. Migratory birds and bats. I would like to see some language around this, and I would like to ensure that this section not only includes birds but also bats. Studies on bats. Wind turbines are primarily going in agricultural areas, and bats are very important to agriculture. They're actually really good at controlling insect populations. An ice risk assessment. I've provided some example language there as well. This is something that I've often heard about, ice throw, but just recently seen where it can be assessed to provide protection to citizens. While it is true that there is not a lot of ice incidences, in fact, turbines do have technology built in to identify when ice buildup occurs and they're supposed to shut off. However, rare occurrences can be tragic. This is a small thing that can make a big difference. I understand this is a very small risk, and it likely always will be, but this is an attempt to quantify it so that it will never become to a point that it is unacceptable. It's an added level of protection to ensure that the safety of those living, working, and driving among the turbines, and it does not make it more restrictive. Buried transmission lines. It's important to remember that these are private companies. They're not public utilities. Therefore, the location of buried transmission lines are not located by calling 811, Julie services. Having GPS locations of all buried lines accessible to the county should be required, and would be easily attainable at the time of installation. More information would never hurt the county. GPS technology is not foreign to any of us, and it would be beneficial to have on record the location of all buried lines within the county, especially if there's a chance for abandonment one day. Liability insurance. I feel very strongly that the limits defined here are inadequate and possibly outdated. I do see that there's a way to update them with inflation, but I don't feel that 5 million and 10 million are adequate today. Decommissioning plan. This is a large liability for the county, and you guys have already spent a little time discussing this. It's a huge liability for the county if things go wrong. The county should obtain a full signed copy of a decommissioning plan prior to issuing a special use permit. There is additional language that could be added to this ordinance without making it more restrictive. I'd like to remind you that it should not be, nor is it the intentions of the future for Tazewell County to decommission any of these turbines. That's the responsibility of the developer and the owner of the project. The decommissioning plan is in place in the chance that one of these companies goes bankrupt or becomes unreachable. Personally, I believe that it should then fall back on the owner of the land lease that has been receiving the financial payments for the life of the project should the company abandon them. This is also a good time to point out and remind you that each project, such as Rail Splitter 1, for example, and Rail Splitter 2, and each of the solar projects that you witness at your ZBA hearings are single entity LLCs. This is the fundamental reason that financial assurance is so important. I've also provided some additional language under the decommissioning section. And that is the end of the wind ordinance.
Okay, my first question is on your first page, item number 3. You refer to the LaSalle Sinclair factors, and are these the factors in that title? Your
1 through 7.
Yeah, 1 through 7?
Yes.
Okay. And can you explain the LaSalle Sinclair factor? What is it? Where did it come from? What?
I did not bring my notes on that up here with me. Possibly.
I don't know the detailed history behind it, but they're currently reflected in our zoning code in the special use section under factors that the board should consider granting a special use. These factors are listed there. The challenge we face is that the Act requires us to modify our code to provide that the request for siting for a wind energy facility will be approved if the request complies with the standards laid out in the Act and the ordinance that's adopted consistent with the Act. So our ordinance right now has those factors in it for all special uses, including wind, but the Act seems to require us to not apply those factors in applications for wind and solar.
Okay, so in a regular zoning case, we refer to them as finding of facts, and that's part of this LaSalle Sinclair similar type things.
Right, you're supposed to look at the facts that are brought before you at the hearing, and then based on those, make findings as to each of those factors, okay, whether the project would be positive or negative.
Okay. And then on page 2, item 4, C, you want to add that APLS lighting system to all towers. Is that the way I read that?
Yes, it would be all new projects brought forth under this ordinance.
Okay, but if I remember right, in the original United Citizens proposal and the discussion and the meetings that we had, that was only available around major metropolitan areas, Chicago, St. Louis, Los Angeles.
I don't believe that to be true. There's one in DeWitt County, I believe it went in on that one, and there's an active one. I forget what exit it is. Marshall County.
Okay, like I said,
You can see the right by Woody's restaurant. You can see the system sitting there by the interstate.
And then on later on in that page, number 5, and you use the term, and I don't know if it refers to this section or not. Okay, so it says any physical modification to the system that alters the mechanical load path or major electric components shall require reapplication of a special use under this ordinance. And then I interpreted when you were talking, it like a person would remodel something. So are you asking that if they take down the turbine and the mansell that's on top and replace a new one up there because it's more efficient, that they give a new special use report, special use permit?
I believe it should be heard as under a new hearing, yes.
I did hear your answer, Amber.
Yes.
You said yes to his question.
If it is not like kind replacement.
Not what?
If it,
Can you twist that?
Turn it down just a little.
Yeah.
There you go.
sorry.
Okay, so the way I understood her, and you correct me if I'm wrong, if it's like kind replacement, she's suggesting no, it does not need a new special use permit. But if they upgrade it to a more efficient, newer model, etc., she would like to see a new special use at that time. And what would be the purpose of that though?
Well, if it's new, it may have different safety requirements. It may have, there's a lot we don't know about them that are going up if they're different.
Okay.
How do we know that? I mean, I guess, do they have to check in with you every time they repair something?
So not for standard, like daily repairs or anything like that, but in the instance of a repower where they are going to put a new nacelle or blades or something like that, they would have to obtain a new permit or something like that.
And so when you say regular repairs, we're referring to normal maintenance. Okay.
If I may, Chairman, I can see a real issue with this if they upgrade and I don't know what length of blades are, but say blades are 150 feet long and we have a tower and it's 300 feet high to the top of the blade. Then they come back and say, well, we're going to put 175 foot blades on it. Now they just changed their setback distance.
My understanding would be is they would have to still comply with the setbacks.
Yeah. Yeah, so we want to make sure that we have some type of provision if we know that they're doing major work like that they're not changing setback requirements by changing.
Without notifying us.
Yeah, because.
Okay, go ahead.
Like you said, they would have to come in to get a building permit from her.
Yep.
And part of that would be she would look at their plan and say, well, that's too tall for where you have it.
Okay.
You know, you can't make it that tall in that spot.
That's fine, as long as we have a mechanism in place to control that.
Okay, and then I didn't quite understand at the bottom of that page where you want acoustic testing done every 24 months. Explain that again.
Yeah, these are machines and they will wear out, and there is the chance they will become louder over their lifespan. I think in order to hold them accountable, and we should have regular testing done. Sound is one of, I think, the largest impacts on residents within a footprint. I think it's really important that we pay close attention to that.
Okay, and then maybe Jackie or Matt or somebody can answer these questions or clarify. F and G on the back page, the material handling and disposal, all of that stuff is covered under a building plan. How?
So yeah, there are several ordinances that have waste disposal in the ordinance, and that would not be a problem to include in this. It is something that we would keep an eye on throughout the project, but if inclusion of that is not a problem.
And then part G, the migratory birds and bats, isn't that all part of the Illinois Department of Ag Mitigation, endangered species, et cetera, whatever's included in that?
So some of that is going to be covered. I want to give a little bit more additional thought, but some of that's obviously going to be included in the review by Department of Natural Resources. Yeah. In their review and the EcoCat analysis that they do. And that was something that's included in the statute that the county may require that those materials prepared by the consultation with DNR and Fish and Wildlife should be submitted. I think I need to give it just a little bit more thought to make sure that it's actual overlap instead of something slightly different. So
Okay.
Something worth giving it some thought.
Okay. And then bullet I, GPS location of all buried lines, accessible. I'm assuming that is accessible at the county level or in the county records or?
Correct.
Okay. Wouldn't that be more beneficial if it was with the property owner? They're the ones that are going to call the tile guy to fix tile, or if they're going to trench a new water line or something, rather than have to come to the county to get that information, I would think.
So,
Okay, so I'm going to preface this by saying, and these guys will correct me or say I'm out of left field, but it's my understanding and feeling that there is an obligation on the landowner that signs up for a wind energy project to make sure that they have good legal advice and that their bases are covered. I'm not sure the county can legislate everything that a property owner should take into consideration in doing a project like this or something else. That there's a certain responsibility that lies with them, and they need to work that out in their agreement with the company rather than keep pushing the burden to the county. Yes, no, maybe.
I agree with Mr. Lesson.
Okay. I don't mean to monopolize board members. Other questions? Land use? Yes.
Yeah, no, I disagree with your last statement, and Matt, I disagree with you. I think that's good language. If they make this agreement and it falls back on us, why should it be on us? If the company goes to fund, because you know it'll end up in our lap.
I guess I don't understand your example.
Well, the very last paragraph about putting the onus on the property owner who entered into the agreement.
I thought she was referring to or the discussion was referring to the buried transmission lines.
Oh, I thought
noting the location.
No,
Oh, sorry.
I'm sorry.
my discussion was on bullet I.
Oh, I'm sorry. Okay, I was looking at B. Sorry.
Okay, so what did you want to clarify in this mix-up?
I was just going to clarify that we were talking about the transmission lines, but I would like to add, I agree that the property owner should be, but these are 57-year leases. Property will change hands. I don't see it as a burden for the county to have that on file with today's GPS technology. Lines are going to cross property lines. I do not see the county being hurt by having this additional information available.
Okay, and so let's back up a minute, Matt. Are buried transmission lines covered in the decommissioning section of the act? You check real quick.
They're discussed in the aim.
Yes, in the ag and mitigation part of it.
Tells how deep they have to be.
Cables have to be removed to a depth of 5 feet. Cables that are deeper than 5 feet may be left in place under the mitigation agreement.
Also in the mitigation agreement, it talks about electric transmission lines that when they're in place and you have to cut through a tile line, then the company has to provide to Illinois Department of Agriculture a strip map showing where all that transpired. Plus, they have to give a copy of it to the local soil and water conservation district so they can help the property owner with future drainage needs. So they're going to know where those lines basically run based off of that.
Okay, so there were two in there. One copy was sent to the state or the Illinois Department of Ag.
Yep, with an as-built drawing. They say strip maps.
Okay.
Showing location of all tile lines damaged in the construction of the wind farm. The drawings and GPS tile line repair coordinates will be provided on a county-by-county basis for distribution by the Illinois Department of Agriculture to the respective local soil water conservation districts for the purpose of assisting landowners with future drainage needs. And it goes on to say in section M, in addition, after all construction is complete, all affected landowners will receive a copy of the tile repair location map with GPS coordinates identified as the electrical cable crosses their property.
Okay, so there is copies locally with soil and water and, okay, the only thing they didn't include in there was those farms that are in a drainage district. Certain areas have drainage districts, and then the drainage district monitors the tile and the ditches within that district. And most of the landowners that are in a drainage district, then that's included on their tax bill. So I would think if we could add verbiage to that part of it to include drainage districts, or is that double
Well, this is in the agreement that the Department of Ag is in the AMA, which is not something we have.
It's not, okay, or it just says you gotta follow AMA's rules.
Right. Okay. And I do want to note, I think, if I'm understanding you correctly, that provision wouldn't apply if there was no broken tile. You know, I think she's talking about mapping of all the buried lines.
I believe you're correct.
So it wouldn't necessarily cover everything she's talking about.
Okay. Okay, other questions? Board members, land use? Yes.
She has the question for setbacks. What does the process look like if these are changed at the state level? Can that be answered?
Yes, so if the legislature were to amend the statute to require, or to expand our ability to set these things back, to allow them to be set back farther, we would have to, I'm sure that the Community Development Department would propose an amendment, or I mean, anybody on the county board could do the same, suggest an amendment, bringing it, our code into line with the new powers we would have under that act, and then it'd have to be going through the same process we're going through now. So it would be heard here, and then go to land use, and then county board.
Can I
Yes.
ask another question? So there is a trailer bill at the state level right now, and their session is the 19th. Land use will meet the 9th, and the board will vote on this at the end of the month. If that trailer bill passes between land use and the board meeting, is it possible to add it at that time, to change the language at the board meeting?
The county board does have final say, so if they choose to change that at that point, they would be allowed to do so.
Thank you. And okay, other questions? Okay, thank you.
Thank you.
Yeah. Scratch it up. Okay, fingers okay? Okay, we're gonna take a 5 to 7 minute break, and then when we come back, Craig Kilby will be next. And the key is on the way to the bathroom.
I believe the key was just taken, so just head towards the restrooms and we'll have the handoff out there.
Hey, good to see you, dude. How's your bride? Yeah, my bride's a lot better.
This conference will now be recorded.
We're going to reconvene, and before the break, I had announced Craig Kilby was next, and he informed us during the break that he was going to leave and not be able to present, and a lot of what he had, he said had already been said, so in order to not repeat, we are going to Tim Bear next. Name and address, please.
Tim Bear, 23785 Augustine Lane, Tremont, Illinois.
And do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Okay, Tim, your comments?
In my comments tonight, I propose an amendment to the Tazewell County Wind Energy Code that good neighbor agreements shall not be permitted or gag orders. I also propose that the facility operation manager of these WEX projects shall live in a house situated equal to or closer to a wind turbine than any other citizen. I further propose that this house shall have set business hours once per week where the public may submit any complaints or issues that may arise. The value of the facility operation manager living near a wind turbine is that this person will be able to understand any problems that may arise, as this person will already be experiencing the same problem. Also, because this house is owned by the facility owner, recording equipment could be installed in this house to document any issues. Next, I want to address the decommissioning plan to propose a one-sentence addition. Quote, after all available decommissioning funds have been utilized, the property owner of record is responsible for any remaining costs to complete the decommissioning project. End quote. By adding this sentence, future taxpayers of Tazewell County are protected from any costs arising from the WEX decommissioning projects. This should be a non-controversial issue as the WEX owners have already agreed to fund these costs. Assuming the WEX owners fulfill their financial commitment to decommission these projects, this one sentence addition to the decommissioning plan will never become effective. The value of this one sentence addition to the WEX ordinance is that it helps ensure honesty in setting aside decommissioning funds, as there is now accountability in an issue that was lacking accountability and funds in earlier WEX projects. Another area I want to address is setback requirements. As of today, we know what Illinois law requires, and I accept that is the law. But I am strongly opposed to the addition of state setback requirements in the Tazewell County WEX ordinance. I propose that Tazewell County adopt much more reasonable setback requirements in its WEX ordinance, as state law can change or it could be modified by the courts. By having more reasonable setbacks as part of the Tazewell County WEX ordinance, all WEX owners would be on notice that Tazewell County wants to protect its citizens, and WEX owners can then plan accordingly. I recognize that Tazewell County needs to be in compliance with state law now, and this can easily be accomplished with a one-sentence addition to the Tazewell County WEX ordinance. Quote, Tazewell County setback requirements are subordinate to state law setback requirements until such time that state law setback requirements are no longer valid or in effect. The value of that is that Tazewell County would have a better ordinance in effect once state law, if it ever became not valid, would already be in effect. And so I have a question then, I guess, Dwayne, would you be the right one for the board?
We'll see.
Or maybe one of the attorneys. What is the purpose of setback requirements?
I'll let those address them, but The one obvious one that I can think of is you don't want the tower to fall over on the road, so you need to be 1 1/10 or 1.2, whatever the act says, away. So if the tower topples, it's not on the road or house or property line, etc.
Or maybe on something.
Any addition?
Take whatever steps that the state deemed necessary to minimize risk and ensure safety.
I guess that wasn't the question. The question I was asking is, what is why have any setback requirement? What is the main purpose of setting? In other words, not state law. We know what state law is. I guess my more fundamental question, what is the purpose of setbacks?
To minimize risk and ensure safety.
That's, I think in other words, you could sum it up with safety. It is, in my opinion, that covers a lot of ground. In other words, it's physical safety for public and also property safety. They fell over.
Right.
And so in our research, when we were working on the WEX proposal, in the wind turbines, the wind turbine companies' own literature or safety, I don't know if it's requirements, but it was guidelines for their service personnel that in case of a storm, and I don't know what the height was of these turbines, but this was prior turbines, so this would be shorter turbines than what's being proposed now. But it was 3,250 feet, if I remember. That's what the wind turbine companies felt was needed for safety. And of course, you're well aware of what state law is, their setback requirement. Basically, state law is saying we care less about public safety than actual WEX owners by their setbacks. So that I guess that was my question, and I was hoping that to be part of the public record that people understand clearly, what is the purpose of setbacks? In my opinion, it would be safety, and that was the answer I got, and that's what I was hoping to get. So.
Okay, you quoted some specific language and
you're going to get the copy of that if you want that.
Okay. That's what I was going to say.
Yeah.
It needs to be on the record.
Yes.
I jotted it as best as I could.
No, you can have that.
So, okay.
Publish it. Right.
Questions? Zoning? Land use? Yes.
I think there was either 3 or 4 points that Mr. Bear made, and I partly agree with the 2 of them. I don't know whether there's 2 or there's 3 or 4, but I strongly agree with 2 of them, and they are his 2 sentences. I'm going to speak them so they go on the record. One is one sentence added for the decommissioning plan, and that's this, quote, after all available decommissioning funds have been utilized, the property owner of record is responsible for any remaining costs to complete the decommissioning project, which means that the county and the taxpayers, therefore, are not on the hook. The other comment that I agree with is regarding setbacks. And one sentence says, if I can find it. Yes, here it is. Tazewell County setback requirements are subordinate to state law setback requirements until such time that state law setback requirements are no longer valid or in effect. Now, you might say, duh, that makes common sense. That goes without saying, you don't need that sentence in there. But I've been in government for almost 50 years, and you do need it in there because sometimes we, being political people, become anal. And what that says, even though it's common sense, is argued by elected officials or whether it's true or not. And there should not be an argument of whether that's true or not. But I'm sure that anybody in Springfield who put this in, who now doesn't have a majority to keep it in, would argue that it's not true. And so I agree with Mr. Bear, and I wanted those two sentences in the record, and I plan on probably modifying this. I can't do anything tonight, but or request that the ZBA do that. But if they don't do that, I'll have to wait till the plan is. Thanks.
Yes. Yeah, and so I want to second again, I guess my own comments that Russ just mentioned. The problem is if Tazewell County adopts state setback requirements in Tazewell County Code, then that's in Tazewell County Code. And if state law goes away, becomes ineffective, court challenge, whatever, then our Tazewell County Code, if it's mirroring the state law right now, then that would be code. And that's what I'm saying, no, we don't want that. Let's put more reasonable setback requirement. We know what the WEX owners themselves are saying. They're saying in a storm, we should be 3,200 feet away. Well, why should you put houses 1 1/10 away? Let's say it's 800-foot tower that's 900 feet. Well, that's not even 1/3 of what
Okay, we've got plenty of attorneys around, and I'm sure you've got some and other people have some. And so by not adopting the setbacks, we don't have to adopt the state setbacks. We can let the windmill company put it 100 feet from the road. We can let the windmill people put it 100 feet from the property line. We can let them put it 10 feet from the property line.
Could I suggest something? I think Mr. Bear might be suggesting our code, having our code read, and I think these are referred to as springback provisions, maybe, that, we acknowledge what the state law says, and that's the rule here for now. But if that changes down the road, then it would be equivalent to having a provision that says the setback for X purpose would be what the statute says now, or what the statute is later amended to say, whichever is greater.
Or it could possibly go away, and that's what I'm saying. We should have a good setback requirement in place, because there may not anything replace what the state does. That's what I'm saying. If you had it in your code now and just say, okay, it's subordinate to, that's what.
Yeah, like I said, you can see they're discussing all the different what ifs and what for and why not. And so I think we understand the gist of your suggestion, and the legal minds will consider work.
Sure.
Okay, take it into consideration, and I understand, and I tend to agree that should they divulge themselves away from this, we need to have something that says this is what we learned.
And something much better.
And what is that?
Well, I've already mentioned what the WEX owners themselves say. I think we should use that as a reference point.
Okay, but you referenced that from a previous meeting, and that was discussed heavily at the previous meeting, and there was contradictions as to the accuracy of it. And
well,
so,
no, that's in their literature. They don't publish it anymore. But that's why
that's what I'm saying. There's a reason why they don't publish it anymore, because it may or may not have been accurate or inaccurate at the time it was printed. Whether it was a typo or we don't know. That's the problem. We don't know. And so it's one of those facts that can't necessarily be proved.
Well, it can if the WEX owners in their service literature as of today, I would assume they have safety requirements for their service personnel saying, okay, if there's a storm around, we want you.
Well, we don't want to adopt that, because if that's something less than what we would desire.
My suggestion is it would be more than that. And that's why I was hoping to publicly ask the WEX owner tonight, what is that number?
Point of order, Mr. Chairman. Okay, now,
Yep, and so we need to stay on the path. Any other questions? Okay, closing comments?
I'm done.
Okay, thank you.
Thank you.
Okay, Kelly Sands Reisinger has already given us her personal, but she's got a couple points or questions, and so we're going to allow her a short period of time. Yep, come on up here, and you're already sworn in, so.
Hi. I just basically have
Name and address.
Kelly Sands Reisinger. I live at 25880 Boynton Road in Delavan.
Thank you.
Basically, I just have some questions that I've been trying to take some notes on. And I think maybe I heard Randy even kind of mention this. I'd like to know who's monitoring that they are within compliance. I know that that zoning is involved in that somewhat, but it kind of seems like there's not like I almost think it would make more sense to have some type of a public entity, since this is kind of becoming very broad-based, wide spectrum across the state and even the nation. And so I guess it's a little frustrating because I feel like there are issues of non-compliance that are being ignored. So that's a concern of mine. It's also a concern of mine when you talk about the participating landowners who are responsible for working out logistics or whatever with their own attorneys, but what about the non-participating landowners who don't have lawyers or don't want to pay, all this money to hire representation like that, or maybe they don't have the money for representation? I'm concerned about how are they going to be protected from issues like with what I mentioned in my testimony, where it was put up anyways without any type of agreement until after the fact. I think we need to try to avoid situations like that where people are put into those types of situations, because they really shouldn't have to be dealing with those things. Let me think here. Another concern that I think I have is with board officials who vote on these ordinances, and whether or not there's a conflict of interest with those, with them, and in particular, whether or not they have family members who are, or themselves are, participating in the projects, and should they be allowed to even have a vote when it comes to these issues related to, these types of major issues. So I have concerns about that. And also just a question as to, is state law supreme over the county, or can the county ordinances be set a higher standard than state law? Even though state law says, yes, this is what, these are our guidelines, but can the county set their own guidelines to where, and maybe that's what is it Tim?
Yeah, Mr. Bear.
Mr. Bear was kind of talking about, whether or not they really have to just go along with the state law. And also, when were these state law setbacks created? Was it before the technology where the wind turbines were smaller? In the Boynton Township, they're currently not as tall as what they're proposing to be constructed. So is it even feasible that this is a setback that would be safe, or how much research has gone into that? So I think that answers, I think that was most of my questions there, but.
Okay, I'm going to kind of go backwards. I think Matt referenced it earlier. The act was signed when?
January 27th of this year is when those new setback requirements were put into place
And
by the state.
And so your question of, I think this is, she's asking, do we have to follow that or can we set our own?
So this act, the state act, is a little bit unique in that most of the time, the state puts rules out and then we have room to work around those rules. In this case, this particular act says that we can impose conditions up to a certain level of stringency. So setbacks of a certain size, and it says we can't impose anything greater. It says we can't impose any conditions that are more restrictive than the conditions that they've laid out at the state level. So that's not the way laws are typically written, but it's the way this law was written.
Okay, and then I think you had a question on monitoring and compliance. Is that what you?
Yes, just because I feel like the current system, if it's going to kind of still go along with what, if the new project is still going to be kind of follow the current system, I just feel like it doesn't really work. You know, there's been many instances, and I have things on videos, where there have been noise violations, and I feel like there's been noise violations. You know, living with around these where I have at least 4 within a half a mile of me, and there's so many more within a mile of me that, you know, that's all I see is the spinning, and it makes it difficult to even go out and walk outside. So
we spoke several months ago about this, which led to the provisions that are in the code with regards to complaints, because in our discussion, we realized that those who were tasked with implementing or enforcing the guidelines that were in place, that system was a little bit broken. So now there is information in here that we would take the complaint, and although it reverts to the Illinois Pollution Board, we would ensure through the special use process that that complaint is addressed with the facility owner.
see, I had a situation, and I think I had to contact you about that because I even filed a report about it, and they came out and could tell that it was way too loud, and contacted you. You referred me to the Illinois Pollution Board, and then the Illinois Pollution Board basically said, well, we can't help you either. So, I mean, it doesn't really seem like this current system is really set up to protect citizens, is what.
That's why the provisions are now being proposed to address the concerns and the problems that we found once you did call.
Okay.
Okay, and then your comments about board members and their voting rights, that needs to be addressed to the county board.
Mm-hmm.
And they've got their own procedure and for those types of situations, and I don't think we need any more than that. Do we, Russ?
All I want to mention is that I went to school on your comment, and the gentleman who sat right here before Mr. Minold was a Tazewell County board member, and he owned a tower on his land. And I was the board parliamentarian, and he asked me what to do, and I advised him to abstain, and he did so. And I'm going to add, I've been on this board a long time. I'm not saying that never happened, but to my knowledge, no member has ever abused the conflict of interest policy in Tazewell County. And I wish I could say that about Congress in Springfield. Thanks.
Okay.
I guess in comment to that, I guess I just have a little bit of a disagreement with at least one of your board members. I don't want to necessarily mention names. I don't think he's here this evening, but
okay,
he's a relative
then
of
that
mine.
doesn't deal with the code, so
Okay.
we need to. Okay, does that pretty much answer the question?
I think so. I mean, I still have concerns, but thank you.
Okay. You're excused, thank you. Robert Jorgensen. Name and address, please.
Bob Jorgensen, 212 Sunnybrook Drive, East Peoria, Illinois.
Do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, your comments?
I'm not sure what to say after listening to comments that have been brought forward. You know, I looked at the form here, and of course, you know, right at the beginning, it says wind energy conversion system purpose. So this is the purpose of what this whole farm is going to be. And it's, you know, it's 1 through 5 to assure any development, production, and, you know, I shouldn't need to mention them, but safety is in there. Financial benefit to the, not only to the county, but to people in the county. If I owned a farm and had a chance to put one of these up, I would. And some of you are looking to make things so restrictive that I would not have the chance to do that. And I don't think that's right, to make it so that, you know, people who want to put a tower up don't have an opportunity to do that. E, to promote the supply of wind energy in support of Illinois statutory goal of increasing energy production from renewable energy sources. Great goal. What can possibly be wrong with that? You know, you talked about the wind and the noise that it makes when these turbines are turning. A lot of the sound is dissipated because of the wind. Wind is going through there. 50 decibels in your house, that's your refrigerator running. And you're sitting there next to your refrigerator all the time. And I just don't get where you're going with this to try and be so restrictive. I don't know if I wanted to talk about things that I think should be put into the code. I think I would definitely want to say that if there's a tornado that comes along and it tears the roof off of your house, and that roof goes over and hits one of the turbines and it damages the turbine, that then you should be responsible for the cost of paying for that turbine. Okay, so how often is that going to happen? You know, what are the chances of that happening? And that's been true with so many different things that have come up. The turbines are extremely safe. You know, I don't know how many incidents have we seen on television that shows, you know, a turbine flying off and going farther than 100, the height of the tower and 10%. You know, it's I suppose anything's possible, but you know, I think that the company is doing all due diligence and is working with the county and to make these improvements, make these taxable improvements, make things work for the county, and make our air cleaner. What about all the storms we've been having? What about the people that just got killed? That's climate change. Yeah, I know there's a good chuckler there, isn't it? Science says it's climate change. You look at the weather down along the coast in Texas, how many people have died? That really is climate change. you know, I don't know. Maybe we should have a provision in there too about if a farmer is plowing and a lot of dust comes up from the soil, and this dust, and I'll only say, goes up into the gearing of the turbine, and it seems to affect the turbine, then the farmer should be responsible for cleaning the gears of the turbine to make it run better. I mean, you know that happens. It's got to get up there. I almost hesitate to say, but my one possible suggestion to make people a little bit more agreeable to having wind turbines in their area. And I'm sorry, one more thing I got to say. My wife and I we have to pull down the shade in our family room most every sunny day at between 5 and 7 because the sun shines through and I can't see the TV well enough. And I don't know, it's a pretty easy act to go over and pull the shade down, and you know, it's no big deal. I don't mind doing that. But the one positive suggestion that I would have, and thanks for being so patient with me as you have been with others, is that I know in some situations, and I'm not sure what the numbers are or anything, but the people who do not have turbines on their land, one of the things I thought of is maybe the board could reassess only the value of their home, maybe. And since it's such a big deal, and it's causing so many problems, and restructure it and reduce the property tax, but the property value by 1%, 1.5%, because they're not getting a financial benefit. This is something that wouldn't cost the county very much, might be making people a little bit more agreeable, even though there isn't any specific study that actually shows that property values have gone down. I know there are a lot of studies out there, and you know, we can all read the studies we want to read, but that might make people a little bit more agreeable to they didn't have a turbine on their land. It would take quite a few years, but eventually you'd build up a good set of money that would offset, you know, maybe some of the problems, some of the situations. And I, again, appreciate your time and your patience for all this, and you are all saints.
Board members, questions for Robert? Land use? Any closing comments?
No, I had a whole lot of good ideas about why the turbines were going to be so beneficial, and well, I wish all of you would have been around when they were doing sightings for coal power plants that all the citizens have had to pay for through their health, through their now taxes, by cleaning up the leftover coal ash that's poisoning people's drinking water and the rivers and the fish. And that would have been great if you guys would have, I should have gotten to know you sooner and we could have worked on it together. And then that was going to be the thrust of my talk, was working together with everybody else to try and make the county a better county.
Okay.
So
Thank you. You're excused.
Thanks.
Okay, Emily Hopkins. Name and address.
Emily Hopkins, 201 Northwest Main Street, Hopedale, Illinois, 61747.
You hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, comments?
Thank you for the time to speak with you today. My name is Emily Hopkins, and I'm a project manager with EDP Renewables. We own and operate the Rail Splitter Wind Farm based south of Hopedale, and we're currently developing a second phase of the project. EDPR supports this amendment because we believe the regulations proposed are workable and would allow for further wind development in the county. We've provided detailed written comments to the board with a few suggestions, and we're happy to discuss them further. Secondly, we understand that there are a few items under consideration to add to this proposed ordinance. We have again provided detailed written comments, but I'd like to highlight a few. Firstly, ADLS, or Aircraft Detection Lighting Systems. This is a new technology. It cannot be installed until at least 6 months following project operation, and typically it requires 8 to 12 months for a complete installation. In many cases, installation is problematic due to the complexity of the system. We've heard concerns from aircraft pilots regarding the lighting activating properly, given past issues with the system. So we would suggest that if an ADLS requirement were to be included in an ordinance, we would encourage an allowance of 1 year be given post-project operation to allow time to successfully install the system. Secondly, I'd like to address the concerns with birds and bats and concerns around their protection. We perform extensive studies and consult with the Illinois Department of Natural Resources for a recommendation on how best to site turbines while considering impacts to birds and bats. Further requirements would significantly impact the area in which we could site turbines. I'd like to conclude with the benefits that our project has brought and will continue to bring to Tazewell County. Rail Splitter currently employs 9 local citizens in full-time positions and previously provided more than 70 jobs during construction. It has contributed more than $6 million in tax revenue to Tazewell County. Approximately $3 million of that has gone to local schools. We estimate that Rail Splitter 2 will bring more than $31 million to Tazewell County, and this revenue includes $22 million to local schools. In addition to this financial benefit, we strongly believe there is support in Tazewell County for wind. We've shared with the board over 50 letters of support from local citizens who believe that wind is a good investment for this county. We've also had more than 70 families with near 10,000 acres sign up to participate in Rail Splitter 2. And I am the one who personally signed these families. I've been working on Rail Splitter 2 since 2020. I have sat down with them, we've negotiated terms, and they want to see this project go forward. But that is not possible without a workable wind ordinance. So we strongly encourage a yes recommendation on this amendment to allow Tazewell County to continue to benefit from wind energy. Thank you.
Okay. Board members, questions? Just land use? Okay, Matt?
Regarding ADLS,
yes.
What is it about that makes it so that it can't be installed until 6 months or however long a period after activation?
So I'm not an expert. I have not worked on a project that had ADLS, but it's my understanding that the lighting needs to work properly with the rest of the turbine system. So it needs to be up and running before they can add that in and then run it together. I'd be happy to put you in touch with someone who can give you more details, but the most I know is that it is a very complex system that's been installed and it's not always worked exactly as expected. So I just want to set expectations that that's the current state of the technology.
Okay, other questions? Yes.
So with this predicted revenue, with this second project, the rail splitter tube, how did you come about figuring out those numbers? And can you guarantee those numbers? Or, I mean, this is just a prediction, so it's obviously something that could, not work out. So how did you come up with that?
Yeah, so we have a preliminary layout that we expect it to change, but we expect there will be 20 to 30 turbines. And we have a preliminary layout that cites each of those turbines. And then the way that tax revenue is calculated is set by the state of Illinois. And so that's on a per megawatt basis. So that tax revenue is using that formula set by the state of Illinois, assuming a 3 megawatt turbine. And then assuming the locations like within each township, that's how we calculated the specifics that would be going to each district.
Okay. Other questions? Okay, closing comments?
Thank you for your time.
Okay, you're excused. James Griffin? Name and address, please.
James Griffin, 70 West Madison, Chicago, Illinois.
And do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Mr. Chairman, members of the board. I will be brief. I have just a few comments on the proposed language. They all relate to the word permit and how it's used. In section 153.02, there are 3 definitions that utilize the term building permit. That's non-participating residence, occupied community building, and participating residence. So in each of those cases, the definition says those things are in existence at the time a building permit is applied for. And we recommend that it should be changed to special use permit because that's the time where the zoning board and the county board and the zoning administrator is going to be reviewing the site plan to determine whether the setbacks are satisfied at the special use permit process. And so those building permit references should be changed to special use permits. And otherwise, essentially, if you read those definitions literally, those things aren't even in existence until you apply for a building permit. Of course, they are in existence. Those homes and buildings will be there. So I think and I think that's also consistent with the statewide standard, which uses the term permit, it doesn't specify, but I believe the intent is special use permit. So that's 3 changes to those definitions, substituting the word building for a special use. And then in section 153.05, there's a section called compliance with additional regulations. And at the end of that, it talks about that the applicant has to comply with all state and federal regulations prior to permit issuance. It says permit issuance, it doesn't specify. We recommend specifying, in that case, building permit issuance, because there are a number of state and federal permits that are not available to be obtained before you have a special use permit, such as your IEPA permits for construction. You would not obtain those until you're ready to construct a project after special use permit approval. And I think that just clarifies the intent, and that makes it easier for everyone to know what the rules are. So other than that, on behalf of Invenergy, we do recommend approval of this proposed text. That's all I have.
Okay. Board members, questions? Land use? Yes.
That's for the, so if we don't make those permit changes? What's the negative impact on you? Still gonna be able to live and do your job and build wind farms?
Yeah, I believe so, but I think that
You're just being, I'm not being argumentative, I have a serious question. Are you just trying to drill down and make it the best language you know how, rather than say this is an obstacle or a hurdle that?
no, I think that when the county is considering an application, by this I mean a special use application, it wants to assess whether the project meets the setback. And so that's what I'm proposing you change the language to do. Rather than say, we'll only address the setbacks in building permit. We're not going to address them at special use permit. They should be addressed at special use permit. That's the time when the public gets notice and everyone can come in here, look at the site plan and identify whether the setbacks have been satisfied. That should occur at the special use permit stage. It'll occur again at the building permit stage. Yeah, it'll occur again at the building permit stage. The staff obviously will confirm the actual location of a turbine meets the standards, but it also should be reviewed at special use permit.
Well, I think we'll talk about this with the staff, because there's a different process we use between the building permit process and the special use.
Okay, other questions? Any input or? Okay. Closing comments?
No, thank you.
Okay, thank you. You're excused. Amy Antonelli. Name and address, please.
Amy Antonioli. My last name is spelled Antoniollii, and my address is 233 South Wacker Drive, Chicago.
Do you hereby swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
Okay, comments?
I represent EDPR, and I'm here today to add a couple comments in response to some of the suggestions we heard tonight to add to the proposed ordinance that's on the table. So to begin, we have two comments in response to the proposal to add post-construction studies for shadow flicker and for noise. Just as a point of explanation, the model that is standard industry practice and that EDP Renewables uses factors in very conservative measures and inputs. The company would like to avoid any violation of law and takes every step to do so. So factors in measures such as 100% sun during daylight hours, no vegetation, and that the turbine blades are moving 100% of daylight hours. And so taking these steps really provides a conservative model for shadow flicker, for example, conditions that just typically don't exist. In Illinois, we know that there's cloudy days. And for noise, again, the model that's used is based on very conservative inputs. And so EDP Renewables takes every effort, again, to comply with Illinois law. In addition, say the point two is there is a complaint process that's already in the proposed ordinance for any issues that may arise with noise, and that citizens, people in the project footprint can take to address those issues. And then the other issue that I'd like to address was the proposal to provide underlying wildlife reports. Just as a point of information too, those reports that are submitted to state and federal agencies often contain proprietary information that isn't available to the public, but they are relied upon by the experts at these state and federal agencies, and they are used to make their decisions, which then again, the company needs to adhere to. So those should not be required to be submitted to the county, but rest assured that they are considered. And that's all I have.
Okay. Board members, questions? Land use? Yes.
That's an alley, right?
Yes, that's right.
So on this last item that you mentioned, would it be okay in your mind to submit them to the county if you redacted the parts that you didn't want anybody to see?
That I'm not sure of. The initial inclination is that those reports, wouldn't be very useful because they would, if they have redacted information.
Well, I meant just redacted proprietary information or personal information or information that is typically redacted that you want to isolate from public consumption. I didn't mean the nature of the way you put in the report. Obviously, that would not be.
I would have to talk to our wildlife experts about that.
Thanks.
Other questions?
Yes. I may have misunderstood you, so I want to be sure. Did you indicate that the shadow flicker modeling software you use right now assumes clear skies all the time?
It's the best industry practice that when modeling shadow flicker, these very conservative assumptions are taken into account.
So it might not be 100% clear skies, but it's very conservative compared to real world.
Real life, exactly.
Thank you.
Okay, other questions? Okay, closing comments?
None for me, thanks.
Okay, thank you. You're excused. Joyce Blumenshine, Shire. Shine. Isn't that an R? Okay, name and address?
Is Joyce Blumenshine, 2419 East Reservoir in Peoria, Illinois. I grew up in Tazewell County.
Wait a minute. Do you hereby swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and you did not sign in ahead of time, so you cannot ask any questions, but you can still be cross-examined, and you're going to have a time limit.
Yes, sir, and thank you very much. Is it 3 minutes or 5 minutes? I forget.
3 to 5.
Thank you. I will be brief. As I mentioned, I grew up in Tazewell County. I have a family of generations here. I'm in Peoria now. I am co-chair for Heart of Illinois Group Sierra Club. Our volunteer group locally has worked for decades on clean air issues, clean water, environmental health for our families and our future for generations to come. Most recently, a week ago, we were down in Powerton area, about the Powerton plant, regarding their coal ash, and that hearing was held at the Avanti Dome. So we are actively involved in what we see as commenting and assisting for a healthier future for everyone. And I just want to thank the Zoning Commission, the board members here, staff, for your diligent work, your patience for the public. Our group is in full support of the amendment for 2330A. The wind farm ordinance contains requirements to comply with state law. Our country is a country of laws, and it is for the greater good. We appreciate this ordinance. And I'll just mention a couple of things in brief, and then I'll be finished. So regarding the sound regulations, we have had various encounters with the Illinois Pollution Control Board. They do things based on their professional science staff. They are the entity that reviews and keeps up with changes in science. So that seems like a very good thing to do and make that a consecutive and continual for the state. We do see that there are many counties in the state. Not every county probably is as lucky as Tazewell County to have the staffing and the professional attention and diligence of everyone here and all the attendance due to many factors. So having something that does equalize regulations across the state, to have standards to ensure protections for public health and safety and for farmland is really important. The agricultural mitigation agreement ensures land affected by projects such as wind companies coming in, that land will be restored to its pre-construction capabilities, and the agreements restore aspects of the impacts and it's intended to protect landowners. So we see this as a really good thing. There are 9 specific provisions just on repair of damaged tiles alone. So there are much more specifics in here, and that we see is really important for ag land and the future of ag land. And then in closing, just 2 short things. The height ratios are really important. As technology changes, and we know it will, as more efficiencies come in for wind turbines to reduce the impacts on land, then that ratio, because it's based on the heights, will of course have greater length of protection. So that's really important. And then in closing, it was mentioned about the tax revenues, the importance for the counties and the future. I want to add the importance for property owners who value keeping their farms with their families, facing continually rising costs of inputs and challenges of aging populations, perhaps in the families. It's their choice if they want to sign up for a wind turbine and have those advantages of an annual reliable income. They should have the right. Thank you to Tazewell County for this time tonight, and we hope that this will proceed.
Okay, wait just a minute. Board members, any questions for Joyce? Land use? Thank you. You're excused. Okay, that concludes the public portion of the testimony for the wind farms, and we are gonna, you want a break? We gotta do the solar farms yet. Yeah, we have 2 speakers for the, okay. And so our next case tonight is 2331A, the petitioner's Tazewell County, proposed amendment for the solar energy ordinance. Health Department and Soil and Water made no comment. Farm Bureau had no comment. Highway Department had no issue. John Oliphant, the City of Washington, supports the proposed changes. Okay, Jackie or Matt, somebody want to give an overview of the solar update?
I would love to. The purpose of this suggested amendment is pretty much the same as the last one. Briefly to recap, the state on June 27th proposed a new, January 27th. This new public act took effect, which requires us to place restrictions on commercial solar energy systems only up to a certain extent. If we do not amend our ordinance by late May to comply with the restrictive provisions of this act, then we will not be permitted to place any restrictions on the placement of solar farms, including things like setbacks, vegetative screening, stuff that we all wish to be able to do. The changes made from this amendment include bringing the setbacks into compliance with the new state act, specifically requiring that components of any solar facility be situated 150 feet from occupied community buildings, 150 feet from non-participating dwelling structures, 50 feet from public road right-of-ways, 50 feet from non-participating property lines. It allows the county to require the developers to install fencing at a height of between 6 and 25 feet. It allows the same noise controls as we discussed in the last case, which essentially are coterminous with what the Illinois Pollution Control Board allows. It provides similar provisions for construction and decommissioning and requires the developers to enter into a agricultural impact mitigation agreement that has a decommissioning process described in there. It allows the county to require the provision of vegetative screening and a vegetation management plan for the facility. There are a couple of things that the state statute lets us regulate, which I believe may not be in the amendment. Okay. So I think the big one that the state allows us to regulate that's not in the amendment as proposed, but that you may want to consider adding, is restriction on the height of these facilities. The act lets us limit them to as low as 20 feet. We can't set a lower limit of, say, 15 feet, but we can set a limit, and our limit can be as low as 20 feet for the maximum height of the facility when the panels are at full tilt. We can also require the developers to provide the recommendations from an EcoCat report, to provide the results of consultation with the U.S. Fish and Wildlife Service, to demonstrate avoidance of any protected lands that are identified by either the Department of Natural Resources or the Nature Preserve Commission, and to consider any additional setback recommendations that DNR may have. We can require them to consult with the State Historical Preservation Office to make sure that any historic sites, to make sure they receive information on likely impacts on historic sites. And we can require the developers to enter into road use agreements to cover the reasonable cost of improving and repairing roads for reasons uniquely attributable to the construction of the facility. And finally, we can require them to, and some of this is covered by the mitigation agreement as well, we can require them to repair any damage that is done to drainage district facilities during construction.
Okay, so was this part of the same act from the state that the wind was? It was all lumped together?
That's right.
Okay. Comments, questions, board members? Yes.
So do we have the capability to put into our portion of it that we take into consideration municipalities' comprehensive plan?
Our restrictions on solar farms are, under the text of the statute, subject to the same limitations as our restrictions on wind farms, which, let me get the exact language here so I say it correctly. So first of all, as I mentioned earlier, it says that we cannot place any restrictions on the installation or use of commercial solar energy facilities unless we adopt an ordinance that complies with the act in its entirety. And furthermore, that a request for special use or for siting approval shall be approved if the request is in compliance with the standards imposed in this act and with the standards adopted by our zoning code consistent with this act, which is, 6 of one, half a dozen of the other. And then any conditions imposed under other state or federal statutes and regulations. So I don't see where that consideration of the 1.5 mile planning boundary fits in there.
Even though we go and register the comprehensive plan for the state of Illinois, and it becomes a guiding document as far as the state's concerned on our municipality's growth over the next 20 years.
I see what you're saying. I mean, yeah, the state seems to have made a judgment. I mean, I don't want to speculate on what their logic is behind it. I mean, other than to say, well, I would be speculating. The only thing I can think of is that, in being charitable, perhaps they view these uses as temporary. I mean, the decommissioning plans contemplate that they'll be decommissioned in 30 years, 30, 40 years, something like that. So maybe that's the logic. But I probably shouldn't have speculated.
Okay, thanks.
Jade? Yes.
Like we did a couple hours ago on wind, we had sort of a general discussion prior to digging into the deep language. And so I think this is a very meaningful discussion, Matt. I appreciate your comments. And especially I appreciate Todd's inquiry. So I'm trying to figure out how to diplomatically say this without personally embarrassing you, Matt. And I'm challenged. But you sat through a hearing that went from 5:30 p.m. to, I don't know, I got home about 1 o'clock in the morning. So probably after midnight, clearly it was the next day, Tuesday. And you heard lots of discussion by the ZBA. Some of the members are here, but we have members that weren't here and members that were here that are not here, but you get the idea. You were still their legal counsel. And we had robust discussion, which I agreed with. I did meet with the mayor of East Peoria at 9 a.m. the next morning. And by the way, that was a really short night. And he wanted me to give his appreciation personally to every member of the ZBA. So I do now. But Matt, you never said, oh, by the way, what you're intending to do, and by the way, we did unanimously 5-0, is turn down that petition. And one of the main reasons clearly in the discussion was the objection, strong objection of the only growth route, which is to the south for the municipality, second largest municipality in Tazewell County, East Peoria. You never said, oh, you can't do that. Oh, this would be in violation of the state policy. And I'm really keen on those kinds of things. So why are you saying that now? And because you did say at the beginning that all of the new state law had effect Tuesday night, and I agreed with you, it did. So what I'm trying to say is this. I agree 100% with what ZBA did and the way they did it, and especially the way the chairman handled it and staff. And I think we had the right outcome. What I think is flawed is your overly strict interpretation of the state law when it comes to solar ordinances. And you're saying that all of the history of the process that we developed in the Tazewell County zoning ordinance, because I'm old, I was there in the 70s when we were creating it with Lloyd Johnson and Pinkerton from Dry County, is flawed. And we don't worry about community development plans. We don't worry about 1.5 mile. I think that's absolutely 100% wrong, Matt. And I worry if you're coaching a sitting ZBA on those things, they're at best a guess on your part. And I do know, you've heard me say a lot that case law is going to determine some of this stuff. I guarantee that case law will determine that, because mayors and city attorneys will take that damn thing to court too sweet. So let's not handcuff us on something that a boogeyman that may or may not arise, and throwing all the rich history, not just Tazewell County, but all the counties in Illinois, 102 counties, all of the ordinances on zoning and land use that we've developed over the years. It's worked very, very well for counties and municipalities. You don't have to respond to that.
I would like to.
Okay, you can, but boy, let's think these through before we just start telling the ZBA what they can and can't do, especially after you didn't tell them when they just voted unanimously the other way within the last 48 hours.
Well, I think your argument is a very good one. I think it would be best addressed to the folks in the state legislature who passed this broad, sweeping act that undermines the rich history you're talking about. And it's not a matter of my personal beliefs on what I think would be a good idea. And you say that you feel the advice I'm giving is wrong. And that's a word that can have multiple meanings.
Overly restricted.
Well, it's a, there's a question of what's a good idea, and then there's a question of what does the law say and what does the law mean? And
nowhere does the law say anything about not adhering to the 1.5 mile.
Well, here's what, the law does say. In addition to admonishments that restrictions can't be that we can't impose more restrictive restrictions than are allowed in the Act. It says that we have to adopt an ordinance that complies with those restrictions. And then it says that a request, and I'm omitting some words here, but the gist of it is a request for a special use permit for a commercial wind energy facility or a commercial solar energy facility shall be approved if one, and I'm inserting the one, I'm just trying to make clear my point here, shall be approved if the request is in compliance with the standards and the conditions in the new Act, the zoning ordinance that's adopted that's consistent with the Act, and state and federal statutes and regulations. So, if there's room in there for that 1.5 miles, I'm open to being corrected.
I'll say, and then I'll get off of it, Mr. Chairman. I used to teach the Constitution, and the Constitution doesn't say anything about modern aircraft, because it didn't exist when they wrote it. Now that, under your interpretation, that would mean modern aircraft's illegal because it's not authorized by the Constitution. That's a strict, very strict, over-restrictive interpretation. There is also a more loose interpretation that means things evolve over time. And that's what I think we ought to use here. Thank you.
All I can do is provide you with my advice, and I cannot force you to follow my advice. And you know that. That's my role here, and I'm trying to do the best I can. And I do want to know, by the way.
You're a great counselor.
Okay, could I address the comments about last night?
Last comment.
15 seconds. Although I did not specifically address the recommendation of the East Peoria Planning Department, I did mention repeatedly those three factors that I just listed, and note that those are the only considerations, under my interpretation, that the statute allows for these special uses now.
Okay, and these are going to be the final comments on this situation. Obviously, I was at Tuesday night's meeting, and I'm going to correct you.
Go ahead.
We only made a recommendation. It was a non-binding. We have no authority. And so it was only a recommendation to the county board. You also have to understand that we as the zoning board were still under our old, I'm going to call it old current Tazewell County solar code, because the county board has not adopted or anything similar to the Act yet. And Matt told us repeatedly these three things, that you're in violation of the state Act. And I made the comment several times, boy, aren't we between a rock and a hard place, because we have to uphold the current code, but yet we have to supposedly support a new code that the county hasn't adopted yet. And so Matt was direct with us and said, this is what the code says. And so that's how we ended up. And land use and county board will sort it out. Okay, on with other questions. Yes.
I just have one other quick request. Matt said maybe additional Illinois regulations or statutes. Could we just get a clarification on that to make sure that we understand that municipalities may not have any say in it, even though they have a comprehensive plan? Or the other side of the coin is we really do have a whole lot of say, because there's some Illinois regulation that says we have a lot of say what goes on within the 1.5 mile boundaries. and I don't know how long that'd take, Matt, but, quick email just to update us, I'd appreciate it.
I will see what I can find for you.
Okay.
Okay, Amber, solar comments. Name and address, and you're already sworn in from a previous case.
Amber Toll, 29300 Warwick Road, Mackinac, Illinois. And I'll be very brief on this one. It's planting season and I ran out of time to prepare for solar. I believe that there are several things with the wind ordinance that I've suggested that would also align with the solar ordinance. One, for instance, is the LaSalle and Claire factors. I would again like to ask that those be added for solar as well. I think they are relevant and should be still considered going forward. A couple other items I'd like to make note of is the substation lighting, limiting that, taking into account the lights that are going to come off of a substation within a solar field, limiting the time in writing from the time of the application to the time of the building permit, from the special use permit application to the zoning or building. Warnings posted on the fence for high voltage, and also an emergency telephone number for people to call. Drainage tile, the equipment used in solar to install solar panels is much lighter than wind farms, so it may be overlooked. However, you are driving posts into the ground, and if there is drainage underneath. I've been to several ZBA hearings. A lot of times you guys do take that into account, but I think it would be good to provide additional detail around that. And then finally, an annual inspection after the project has been built. Again, at application time, they can prove it on paper, but going forward, making sure they're maintaining compliance, not they jumped over the fence and now they're good to go, maintaining it, compliance ongoing. So. That's all I've got.
Okay.
So.
Board members, questions? Land use?
Were you here Tuesday?
I was not.
Somebody recommended that from your group, recommended that same posting with the contact information on the petition for the wind farm that was recommended to not be approved.
Solar farm.
Yeah, solar farm. I said wind farm. Stand correct. Solar farm. I just answered I was going to ask if that went through. No, we turned it down, so there were no conditions on it. So thank you. But I think that's you know what section you would amend that if you wanted to put that in? Or you've not looked?
I haven't looked at that one.
That's
Too
great.
detailed,
Thanks.
sorry.
I'm done.
Any other questions? Okay, thank you.
Thank you.
Closing comments if you have any.
No, thank you guys for your patience tonight.
Okay. Kelly Sands Risinger, anything on solar? Okay, thank you for your time. Okay, that concludes the public portion of tonight's meeting. We're going to take a short break and start deliberating.
Maybe you'll be out.
And I would like to say, I appreciate your
This conference will now be recorded.
Okay, is there a motion to get 2329A, the petitioner Tazewell County proposed amendment 65 to the Tazewell County Code on the floor? This is the code that talks about the 15 to not more than 45 days notice. Okay, McClanahan moved, Meisinger seconds to get it on the table. Okay. We heard a lot of discussion, and this is my suggestion. You guys can come up with your own suggestions. I would prefer not to spend a lot of time on specific wording changes tonight. But if there are items that you think that land use and the county board should consider, then we would make a list, and then when we take our vote, it would be either the approval or disapproval, and these items are noted that may need it updated or more specifics in the final code. Okay, we've got a question back here from land use. Yep, either close the door or tell them to go outside. Thank you. Okay, your thoughts, ideas. Oh, one of them has to stay open for, Open Meetings Act, sorry. Okay, we heard testimony that maybe it should be like, instead of 15 and not more than 45, it should maybe be something like 30 to not more than 45. I'm not necessarily a 40 to 45 day, because if you get a long weekend, etc., so on and so forth, that is not a good situation. And we also have to take into consideration, all of this stuff is being done by county employees that are being paid with tax dollars. And so we need to make sure that, some of these things do we have enough county staff, etc. Now, that's not part of zoning, but it's in a consideration of what the final outcome is. Okay?
So 15 days is the absolute minimum by state statute, correct? Or is it?
For special uses, right?
For special uses, okay. So people are asking something more than that. I think I gotta support what you said, Dwayne, somewhere in the 30-day window. Whatever works for the staff. It might be 28 days, it might be 32 days, but I'm thinking that's kind of in the ballpark area that we want to be.
I agree with that.
I don't know how Jackie feels about that, because she's got to run the office that does all this.
Yeah, so if we look at the timing of when our deadlines are, when our meetings are, when we have to have the information to the newspaper, that is a very strategic planned process. That again is for the newspaper. I feel like we could get something out on the web or the website much more quickly. So I don't know that we would be hard pressed to figure out a system.
Because usually you got to have it into the newspaper like 7 days before you want to publish, right?
Right, so our filing deadline is tomorrow. We have 2 meetings this week, a meeting next week. Legal notice has to get to the newspaper by noon next Friday, so we're in crunch time to get it done by Wednesday after the filing deadline of tomorrow. And that's just to hit the 15 days prior to the next hearing. Again, that if we change that system and we thought it was going to be okay going to more than 45 days because our filing deadline tomorrow, then would mean we would give notice in our normal time frame, but bump it to the next month's hearing. So that was going to work. When we're in this conflict of we still have to have the hearing, you know, if it's less than the 45-day notice, we're going to exceed that. But like I said, there's other avenues that gets tricky, but there's other avenues such as posting to the website, requiring or giving consideration to the developers to do the public outreach. I have seen that in some ordinances. We've talked about that a little bit. As far as the mailings go, I'll touch on that real quick. That could turn out to be a huge expense. I think those, yes, would have more reach most definitely than the paper that we publish in that probably no one really looks at. But I think if people are alert that there's things going on and we've got it on a website, that's probably going to be the easiest, quickest, least expensive route.
Okay, you had made some comment in the meeting that basically our calendar for 23 is set. And so by moving these dates, you know, can really contract or affect the current calendar. And so I assume toward the end of 23, they start planning the 24 calendar. And so, but then if you're just pushing everything a month down the road, is there going to be at some point that something could get backed up? Because we do have a limit. We typically have no more than 10 cases per meeting, as well as we've learned in the last year or two that you're not going to do a wind or a solar meeting, a solar application at a regular meeting.
It's another full work day.
It's another 8 hours after we've already worked. And so, I don't know, I guess my suggestion is that we leave the wording the way it is now, 15 to 45. And obviously land use could, you know, restrict it or not restrict it, change it or whatever. And if, and I don't understand the Open Meetings Act, I know a lot of it, but it was my understanding that a website
if you did 100% of them on the website, it served as the official notice. But that was just my understanding.
That is not something I've looked into lately. I didn't know that was going to be.
Yeah.
That's something I thought about for the first time tonight, so I would hesitate to advise you and say the wrong thing. I'll make a note to look into that.
And then, but then that again puts responsibility on the office staff to readjust their schedule and make sure someone is capable and the web's not down and everything like that to get it on. Jake, Amy?
I agree that I think notification needs to be something other, a little more. Newspapers, who reads a newspaper? I couldn't even tell you the last time I opened up a newspaper. So I think notification, and not across the board. I think that's not what they're asking for. I think they're just asking for wind and solar.
Yeah, Class A.
Right, the Class A. And,
right.
I do agree. I think notification needs to be more than a newspaper. We need to get that out more on web. I understand the expense and cost, of mailers and stuff, but I understand their point that when you have acres of ground and farmland and, within a mile, what's a mile when you, when you have property here and you have property over there and, the notification, because it does affect them, within a mile or a mile and a half.
Okay, so are you suggesting that we go ahead and approve these 3 paragraphs as printed with a note to suggest that the county also look into website posting of information? Okay.
And do you also want a similar note to say that they should consider the 30 or 35 days or something like that? Or?
Well, okay, go ahead.
It doesn't, 15 days, I think it's good. I understand their point. They need more time to get things prepped and ready, attorneys and, research and whatnot. But I understand the points of trying to arrange meetings and schedule.
Okay, here's my thought though. Because of the timeline and the schedules, like she said, you gotta have stuff to the paper ahead of time, okay? Right. And so it's the 7 days prior to the 15 days, which, if my math's right, that makes it 22 days. You could put it on the website then, and even on the website, the official notice will be in such and such paper on whatever date. Does that make sense?
It does. Typically the order that we do things in is the priority. So if we have to get it done and to the newspaper by Friday, that's the priority item, and then the mailing process starts. So maybe, we need to get that out, but we can immediately get it on the web, as far as what is sent to the newspaper, the legal notice, and then if we find that
there would probably be disclaimers that, because if something would change between that point and when it hits the newspaper, you see what I'm saying? Right. That the final legal notice is the one that's going to be debated at this meeting or county board or whatever. And so I think that's why she hesitated, is we don't want that website information to be construed as 100% factual and accurate, because we're trying to meet the official deadline. Or I might have worded that wrong, but do you understand the gist? And so there may need to be disclaimers on the website. Right. But attorneys know about disclaimers.
Can I add something?
Yes.
I
Your
just want
staff, Marcia?
Tonight,
You were here till 1 o'clock, weren't
I
you?
was.
You were not your phone, man.
So I just want to err on the side of caution when you talk about the website, the county website. It is somewhat antiquated and it does not work on cell phones, a lot of tablets, which is what a lot of individuals use. So, I mean, just keep that in the back of your mind if anybody's thinking of going solely putting legal notices on a website.
Okay, I'm gonna ask a question. Is the county website administered by county employees, or do we have an outside service that will?
County employees.
I guess I'm just, I mean, within our technology times, I mean, preparing for the future, I mean, how long are newspapers going to be around? So I guess maybe if we get started with this process, we're ahead of the game.
Question, what's the advantage of wording it like this? So it was no less than 45 days prior. Now it's no more than 45 days. So Jackie, what advantages does either one of those for you for getting it in the paper?
The change to more than 45 days was at the request of the public to give more notice to them to prepare for somewhat of a case. The state now says no more than 45 days. So that's where we reverted back to our old language because then we're in conflict with the state. I think now we're trying to find alternative ways to get the information out there as requested sooner. We just kind of have to talk through.
But if you just, let's say you worded it, so the 15 days isn't even in there, you just say no less than 30 days or something like that. Wouldn't that be easier to?
If we can take the 15 days out, we're just legally bound to give notice to a public hearing within the 15 days or prior to 15 days.
Yeah, but like they said, some of the girls up there speaking, they wanted more of a notification for the public. I mean, you'd be accommodating them by wording that so with just one thing saying no less than 30 days or 40 days, then at least everybody out there had 30 or 40 days to see it.
You're saying just remove the more than.
Yeah, I mean, and then try to work with how it works out with you. That's probably more important to me. I mean, somehow, because I just think putting that in, when you say no less than 15 days, immediately some of the people that stood there tonight, that's all they see. We only give us 15 days.
Well, I think what you might be saying is even if we take it out of our code, there's still a state statute that says we have to notify on special uses. We can't, and the 15 days is a minimum. So that's a good protection in terms of notice to the public. We can't notice up a special use 13 days ahead of time. It has to be 15 or more.
Yeah, I was saying just do one number there, just put it out there. I have to do it before 40 days prior to the meeting, the hearing.
I understand what you're saying, and it could be as simple as that because, like you said, people see that and they automatically think we're only going to give them 15 days, where that's not the case. We'll give as much time as we possibly can with whatever notification we can, whether it's by mail or the website. So maybe you're right. Maybe just taking that out alleviates that concern that they're only going to get 15 days. They'll just get no more than 45.
And does that fall in line with the Open Meetings Act then? Because I thought it just says no less than 15. I believe. Right. You still have to meet it. It's just not in writing. It's in writing, but it's not in our code. Okay.
You want that or not? Why?
Yeah. Deliberations are for everybody to hear.
Okay. So ZBA can do whatever it wants with its recommendation tonight. my comments aren't for that, but my comments are for the attorney and for Jackie, because I can tell you one of the things that land use is gonna require.
You can't because you haven't had the meeting yet. You can suggest it to land use, but you can't say that land use is gonna require it because you don't know how the people.
Well, I know one member, the vice chairman, will require it. So anyway, back to this, I think you need to know this. The three requirements are gonna be, there's three constraints and they all need to be included. And so what you do is you figure out what the time is based on meeting those three constraints. The three constraints are, one is the state law, and two is the ability of the office to do its job without changing everything for the whole ensuing year. And the third thing is to get the citizens with the most maximum notice. I think 45 days would probably be it, because you can't do more because of the state. So start with that. So those are your three conditions, and to the extent you can have a range to meet that, that's what we're gonna probably want, unless Tim calls me tonight and tells me I'm full of it.
Okay. I guess I don't really understand your argument, but I do.
What works best for.
Right. I don't want to pound a nail in a coffin, and that's why I'm saying if we recommend it as written with notations that they need to figure out when some type of better posting for the public, and still with the understanding that the final legal notice is the final legal notice, not necessarily what's on the web. And then, like I said, we know it has to be done by 45 days, so. Todd?
No.
Oh, I thought maybe you were. The chair will entertain motions.
One quick question. So you're gonna go through this one piece at a time, notice of public hearing and do something with that, then notice to adjoining property owners? Because there was a suggestion made there, wasn't there? Or do you want it all in one?
Well, I'm just the chairman.
Yep.
My preference is be consistent. I think let's not tell the office, okay, you gotta, this is 15 days, that's 20 days, that's.
No. That's, I think you're misunderstanding it. We're talking about time limits now.
Right.
So we're gonna take care of that. Then the next, there was some, if I remember correctly, suggestions made to notice to adjoining property owners to expand that distance out.
Right. That's a separate issue.
Okay.
That's a separate issue.
I just want to make sure.
This is just the time of notification. This is 157, 481, 157, 482, and 157, 483.
I think what he's saying is that the expanded notice would fall under 482. That's a suggested change to 482.
I see what you're saying, because they suggested instead of adjoining property owners within a mile.
Within a mile. And
okay.
That would have created havoc for us.
Okay, so would you like to debate that separately?
I think we should.
Okay. So we're going to do 157, 481. This is the public hearing. Not less than 15 days and not more than 45 days. Is there a motion?
I would make the motion that the notice of public hearing remain as printed here, 15 days, not less than 15 days, and not more than 45 days, in alignment with state statute.
Okay.
Second that motion.
We've got a motion and a second for 157, 481 with wording as indicated. Discussion. We're in the voting stage. There's only we can discuss.
You said discussion, not voting.
Well, we've got a motion. We've got a motion.
That's fair. I'll defer.
Okay? Discussion from the board.
I'm sorry to interject. I don't know, I'm not sure,
Clarification from the attorney.
well, I'm not sure what this motion is, I guess. I mean, I think they both just said they don't want to make any amendments to that first paragraph. I mean, they don't want to change the suggested amendment. So, I mean,
The way I understood his motion is he's saying, let's take a vote and recommend this to move forward.
thank you.
Is that correct?
Or if you'd like, I would change my motion to say that we recommend approval of notification of public hearing publication as written.
That clarifying? Okay.
Now you gotta ask Sean if he's still gonna second.
No, yeah, but
Are we really moving to stop deliberating on that first paragraph and start deliberating on the second paragraph? Or do you want to vote separately on each paragraph?
well, he indicated that he wanted to have a debate on the second paragraph and suggested that we take them one at a time. And so then I asked, was there any motions? And I'm going to paraphrase your first motion. Move to accept as printed. Okay? His reworded motion was probably more correct. Move to recommend as printed. And so in my mind, they mean the same thing. Okay? You made the second. Do you understand that as meaning the same thing? Yes, I do. Okay. Any further discussion? All in favor of recommending notice of public hearing publication as printed, say aye. Aye. All opposed? Okay. A passes for 157-48-1. Okay, 157-48-2, notice to adjoining property owners. Okay, you have the floor.
All right, so it was suggested by one of the testifiers, I guess, for lack of a better term, that we give, I think it was initially 1.5 miles and then down to 1 mile outside the boundary or the footprint of the proposed boundaries. So that could be a huge, huge undertaking for the staff. If we had had to do that, if Jackie's staff would have had to do that for Tuesday night's meeting, there would have literally been hundreds of notifications you would have had to mail out, because a mile north of that boundary, way north of 474 into East Peoria, and that's a lot of folks. So I don't think you could put geographical limits on it. How do I want to say this? If you're up against a municipality, I don't think you can exclude them if we adopt this. But certainly out in the rural areas, we need to do a better job of notifying everybody around those boundaries. And I don't know how you do that.
Okay, but you had referred to, and I'm going to read it here, that notifications also be sent by mail to adjacent property owners. I would like to propose notifying all property owners in a 1 mile radius of the project for wind. Okay, and when we questioned, it was within the footprint. And so a footprint can be 25 miles.
I understand that.
And so
Just
there's a considerable number there too.
Yeah, exactly. It's just a footprint of those two solar projects we talked about Tuesday night. It'd cost several $1,000s to mail out notifications. Okay. Or potentially anyway.
So what I gather from your discussion is you're, at this point, against changing the wording on that.
Yeah, I don't know.
The way I understand your discussion, we need to address the adjoining property owner, but we still need to be better somehow notifying people in the area.
Exactly.
Okay. But you're not proposing any changes to put that in the code?
Not at this time, no.
Okay. Other discussion?
No, I agree. I mean, I'm on the same way with him. I mean, I feel like we need to do a better job of, running
Dissemination.
references, but, I mean, how do you do it? It's the exact point of, but it's also kind of like Russ said earlier. Kind of goes to show you what we dealt with on Tuesday, why we put it down.
Okay.
So, I mean, I'm looking at like these huge rural areas that, you know what I'm saying? You've got here's a farmer and they've got a property and they've got, how many hundreds and thousands of acres, their land, and then could butt up, to another property that has wind turbines, I mean, that's what I'm saying. I do understand their point, but I don't know how to do it.
Yes.
Feasible and cost effectively wise.
So Rail Splitter 1 is in what, 4 townships right now?
Approximately.
Yeah, approximately. So Rail Splitter 2, I would think would be proposed in is basically the same area. How many people does that take in?
Yeah.
They're very rural townships.
Yeah. I understand they're rural townships, but there's a lot of people living out there in the country.
Yes, and it's, right. Well, the suggestion was all property owners. So that's the 2 acre houses all the way up to the 80 and 160 and 320 acre farms and et cetera. Okay.
So I think you can consider these items and you can decide that you want to propose a change tonight. Land use committee can decide next week that they want to propose a change to the county board. You can leave it as is because there's no great way to change it right now or propose change. It can be an amendment at a later date if you leave things the way they are. And land use committee, county board says we have a lot of other things we need to worry about right now. Let's address this one when we've had some time to think about logistically, financially, how this is going to work.
Yes.
So if the core concern is the sufficiency of notice to surrounding landowners, a better way to go about it that you might want to consider would be improving the signage requirements or the posting requirements for notice of this hearing. Because I think right now it's a relatively small card they have to post, maybe on one side of the site, and that could be enhanced by making them post bigger, more noticeable signs, maybe at multiple locations around the site. If there's public roads on multiple sides of the site, there could be a requirement that be posted, one on every public road or one on every public road every so many feet, something like that. The signage might be able to address what mailing would be an ineffective or inefficient way to address it.
So in the case of a wind farm, would you put them at each
Well, we don't need to figure the details tonight.
I understand, but it's going to be around the whole boundary of the place, or is it going to be at each specific tower site?
Yeah. Okay. So, what's your preference on 157-482? Anyone want to formulate a motion?
I think really, as of tonight, we don't really have a plan of attack to even change that. So I think really it just needs to stay, the verbiage just needs to stay the way it is until there's a better knowledge of the attack.
Okay, and as indicated that it can be amended in the future.
Right. I do like what, as Matt stated, more signage.
Yeah, those are all things that, various proposals that need to be studied and reviewed and cost effective, et cetera. And that's not our job.
I motion to approve 157.482 as written.
Okay, we've got a motion by Kuby, seconded by McClanahan. Discussion? All in favor say aye.
Aye.
All opposed? 157,482 passes. Okay, 157,483, notice to governmental bodies.
Make a motion to recommend approval as written.
Okay, we've got a motion to approve as written. Is there a second? Seconded by Meisinger. Discussion?
Real quick, like that system works. You know,
it appears.
Yeah. My other hat, I get the notifications if something's going on within a mile and a half of Tremont, and we have our opportunity to put in our input. You saw that Tuesday night in one of the cases.
And I think we had input from Washington tonight.
Yeah.
So,
so that worked.
Okay, other discussion?
If it ain't broke, don't fix it.
Yep. Okay. Seeing no further discussion, all in favor of 157,483, say aye. All opposed? That passes. Okay, now we're up to is it okay, because she has to have a record of it, that we put all three cases together on the roll call? All
three sections under that amendment. So it would be the main
What-
vote for the.
150, 481, 482, and 483 on the same roll call. Okay, we will have a roll call on 481, 482, and 483.
Vaughn?
Yes.
Kuby?
Yes.
McClanahan? Meisinger?
Yes.
Chairman Ledford?
Yes.
Recommend approval as written.
I'm glad somebody keeps it straight.
Yes. Okay, 2330A. Proposed amendment to the Tazewell Wind Energy Code. Okay, Matt has maybe some bullet points for us. Oh, wait a minute. Yep, we gotta do. Is there a motion to get 2330A on the floor? Moved by Ball. Seconded by McClanahan. Okay, now we can discuss it. We did have, I'm not sure any of you guys were on the board then. I was sitting right there and we had a very absurd case. I don't even remember what it was. And we should have never even considered it. And I didn't want anybody to make a motion to even get it on the floor. I didn't want it in the record, but I think Crystal made it. So I apologize. It was way out. Okay, so Matt.
So what I did want to note was a couple of restrictions that the new act says we can impose on wind farms that are not in the suggested amendment. So these are things that y'all could add. You could amend the proposed amendment to add these restrictions. Now, some of them are things like vegetative screening and planting and ground cover. obviously, you're not going to block a 700-foot windmill with a newly planted tree. But, if you want to impose these things, these are things that the act allows you to impose. So briefly, vegetative screening, ground cover, vegetation management plan. You can require the developers to provide you with the recommendations from an EcoCAD assessment, and you can require them to comply with recommendations in the resulting natural resource review report. You can require them to show that they're avoiding protected lands identified by DNR or the Nature Preserve Commission. You can require them to consider any recommended setbacks that DNR suggests. You can require them to provide the results of the U.S. Fish and Wildlife Services report, which is called the Information for Planning and Consulting Environmental Review. And you can require them to consult with the State Historical Preservation Office.
With the exception of the vegetation one, I like all of those.
And from EcoCAD on down?
Yeah, from EcoCAD on down.
I felt a little silly mentioning the vegetation plan for wind farms.
The one about DNR and, was it wetlands and their suggested setbacks?
So DNR, they have to, I believe the word in the statute is avoid. We can require developers to avoid DNR's protected lands. And that's defined specifically in the statute as lands that fall under a certain kind of restriction to development.
Is there a different setback to that than there is for everything else?
So we can, not specifically, but if DNR recommends additional setbacks, we can require the developer to consider those.
You can't require them to do it.
Correct.
Yeah, so if the DNR report says you need to stay 1,000 feet from that fragile whatever, moraine or it's in their report, and like he said, it's suggested to the windmill or the WEX project, but if I understood it right.
I think I've answered your question wrong though, because the standard setback for protected lands is 2.1 times the height. So it is additional beyond what it is for most property lines, 1.1, it's 2.1 instead. And then, you can require them to show that they're abiding by that, as well as require them to consider any additional setbacks DNR requests.
I like all with exception of the first one. Kind of hard to transplant a redwood tree.
And this is kind of like what we did the other night. Even though we recommended that solar situation not be approved, we attached all those things to the petition. Should county get overruled and the state issues them a permit to build that, then they still have to abide by it. And so I agree with your conclusion is we need to just include it. It just needs to be included. Okay, and so let's not amend or anything at that, like, whether we want to put it on the list that Jackie's making, that we recommend that land use and county board seriously consider putting these items in the final code. Okay?
We specify them for us.
Well, that's why she's making a list.
Thanks. Then there was comments from Mr. Griffin, I believe it was, if I have his name correct, where he talked about a little bit of language change in some of the
Where you mean? Oh, yes, the permit.
Yeah, is that something that we need to consider cleaning up in the definition? Or are we okay with the way we are?
No, I think it would be best to clean it up. We ran into an issue the other night about the timing of things and whether it's a permit requirement versus a special use requirement. So I've made note of all of those items as well as going through the solar ordinance and cleaning up kind of maybe some of the misconceptions of what that was previously.
So what we sort of like is rather than the ZBA or land use to stick their nose in that, let the office get with the attorneys, figure out what should be in it, let us know.
Okay, other discussion? Do we want land use to consider the wording, Mr. Bear suggested that should the state change their setbacks or guidelines that we have something in place, or?
I kind of like that because I can see somewhere down the line, a county going up against the state and getting an injunction. If we pause this law, or somebody sorts it out. Or some community does that. And I like his idea that we have something there. We're following the state guidelines. However, if those guidelines go away or change, here's what we're going to require.
Okay, and so do we want that on the list, that land use needs to, and the office staff needs to seriously consider adding something to the final?
Yes, right.
And with consultation.
That's my part anyway, that I like that.
Okay.
I don't know where this is going to go.
There was a lot of information presented tonight, and I know you guys feel like you need to go through and you need to make a list, but we've got some items in writing, and then also a number of the land use committee members and county board members were here. They will also have a recording to reference, so anything that we were given in writing, we can distribute to them to let them consider, rather than you guys go through each of those items again, because they're going to consider all of the information that was provided anyway. Or they have the ability.
Yeah, I just wanted to give them the opportunity to identify some points that maybe they felt were unique.
I like the, I was gonna say the one that kind of brought up on the decommissioning, like as far as like, you know, tiles are damaged or, you know, the company is going belly up and the county is not gonna be financially responsible, where I think it should go back on the landowner. I mean, they're reaping the benefits of this for over how many years, and it's their choice, their decision to do this. It should be financially their responsibility if the company that they have a contract with doesn't follow through. And, you know, damage is done to the field for, you know, tiles or the, you know, the underground lines, and all that. I think that should definitely go back on the landowner.
Yeah.
I mean, that needs to, I think that needs to definitely be something in writing.
Okay, and I don't know what all the legal ramifications of all this are, but let's look at an example that happened, I'm going to say a couple of years ago. This farmer had his own tiling machine, and he was tiling his own ground. I'm assuming he did not call Julie, but he hit a pipeline and it killed them, and him and his son. That was in northern Illinois. Okay, so here is an underground cable that's a private cable. It's not identified by Julie, because I know that I had Julie out one time and they marked everything but the cable that went from my house to my barn. And I hit it when they laid a water line because it was a private one. And so how do these public tiling people know that there's an underground cable there? I mean, ultimately, it falls on the landowner's responsibility to notify the person laying the tile that, oh, by the way, there's cables there, but I don't know where they're at. And so,
Well, and that's kind of why
but I'm not sure we can legislate that in a code because a lot of that falls on the responsibility of the landowner, like you said in your previous comment. They are the ones that are getting benefits, annual payments for it. I guess my feeling is if a person that's laying the tile knows that there's a wind farm there, they put in their contract before it, you either show me where the lines are, or if I hit a line, you're responsible to the wind company for that. I'm not responsible. And so, but like I said, I don't think we can legislate that kind of stuff in a code.
Yeah, I want to be sure I'm understanding what you're suggesting, because there were a couple of different things that we were talking about being the responsibility of the landowner, and the underground lines is one of them. But there was also you talked about the firm going belly up or whatever, which I assume means that there's uncovered decommissioning costs. So that's kind of a different.
Right.
That
That
is
is code, can be in the code.
Right. And I think it should be.
Right.
For sure, to cover the county. I mean, you know, you gotta remember these, I mean, I guess these things are, it's not like it's just a 10-year project and it's gone, you know what I mean? This is over the course of, most of us
And I don't know,
won't need to be here.
was
when
that
it's-
on your list that you referenced
Sadly
here
to
a little bit ago to be a little more specific in the decommissioning plan?
More specific as far as including that language.
Well, you're talking specifically of tile, right?
Well,
But I mean, there may be a lot of other.
No.
I think there was a lot of.
Yes, it was all decommissioning costs beyond.
Yeah, all the
Yes,
decommissioning
that's what I meant.
So if there.
Don't
so
limit it just to tile.
Correct. Yeah, that's kind of what I was
Any
just.
cost beyond the cost that's bonded or
Yes.
decommissioning,
Correct.
in addition to would be the responsibility of the landowner.
Landowner. Yeah. I think that's something very important.
But that language is, both those one sentence lines for the decommissioning and also for the setbacks are in Bear's one-page letter.
Yeah. Other discussion? The second page of this.
That doesn't go that. This is the first one. Is that what you're looking for?
No. She had a second page. Yes. Okay, I'm just gonna hit these briefly. Lighting regulations, we heard testimony both ways. I'm not comfortable with this new airplane lighting that,
Where are you at, Chairman?
FAA obstruction, ADLS.
Which document?
Is in Ms. Toll's presentation.
Got it. And which number?
Second page, back of the front page, FAA.
And
C.
3.5.
C.
FAA, got it, thank you. Page 2.
Like I said, It's my understanding, or the way I interpret it, that's technology that is not consistent and available at this time. And this may be like a previous discussion we had, that when that does become more, what do I want to say, accurate, our code can be amended, you know. And this is just my personal opinion. You guys can weigh in on it. I'm on her front page, 15304. Those are similar to what we currently call findings of facts. And my personal feeling is, based on the new act, and it's more specific and black and white, the findings of facts are very, how do I want to say it?
They're excluded from the,
kind of excluded
things we can consider.
that, things that can be considered. And so I'm not in favor of that section. Other discussion from this document or others, or any other testimony?
I think the only other thing that I kind of hit with me was I think in operations and maintenance, I think it was in, that, you know, I mean, obviously, if you're changing things, you know, 5, 10 years down the road, they're gonna put in some, you know, a newer, and of course, it's not gonna be the same. You know as well as I do, it's not gonna be the same as what's there. It's gonna be a more higher powered, whatever. I do kind of agree that I think it should probably be something that needs to come back in front of the board if they're making that big, you know what I mean? One thing if they're just replacing what is there and the same, but if it's changing.
But I think Jackie kind of explained that based on our current.
Then it will have to come back in front of the board then. No.
So I think there's a couple different options to look at or considerations to give. If the project is going to be completely torn out and completely recited, that makes sense. It doesn't necessarily make sense if we'll just say rail splitter 1, because it's here, is going to do a repower. So it's going to keep the same foundation. Now, if it no longer meets the setback criteria, then they would have to require a variance, but not an entirely new special use. So they still have to stay within certain parameters if in fact they want to stick with that same location and that same foundation. I think you would run into an issue of, now we have this infrastructure here, what if it doesn't get approved under the new special use requirement? If they can still meet the safety standards, still meet the setbacks, but they have and I am not technically savvy when it comes to these, but a nacelle or something that's going to produce more power or be more efficient. As I understand it, their interconnection agreement is what it is, so they can't go in and put something entirely new up anyway without having to completely redo the project. Okay. So they would have to get permits, potentially variances, but not a completely new special use.
Okay. So may I ask a question, Mr. Chairman, just to get her to clarify? I understand what's in, and I understand what's out, but I got a scenario that sort of got one leg in each category. So I want you to tell me whether that's it or not. So they've got to change out not just the blade, but all the fans. And while they're doing it, they decide to upgrade to a newer one that generates, you know, more power, and therefore it generates more revenue. So I could see why they had to do it, because it was maintenance. That's sort of in, and they don't need a special use. On the other hand, it's generating, it's totally different technology.
more money or more revenue for them. So my question is, in your view, is that in or out? Does that need a new special use, or is that just maintenance?
So I think there could be a gray area. I think if their interconnection agreement only allows them to put so much power on the grid, they are probably going to have to build or expand their substation, in which case you guys could consider that a new or expanded. They could come back and ask for an expansion of their existing special use in order to do that. I think right now it's a matter of efficiency, not necessarily creating more power, because they would have to go through an entirely new process with Ameren and, like I said, new infrastructure to carry that new power.
Okay, thank you.
Jackie, so when you say it's a gray area, in practical terms, what you're saying, correct me if I'm wrong, is that that's something that would be up to your discretion, because whether they would need a special use, whether the changes constitute an expansion of the special use or not, they would have to come to you to get a building permit if they were to expand a substation or something like that. And at that time, you would decide whether it's a sufficiently big change that they would have to come back here for an expansion, or whether you would just permit that. Is that right?
So I think that would be at the discretion in this amendment of whether or not the board would want to include terminology that we have a total capacity of a project. I can't speak to Rail Splitter 1 and say definitively if we said what that total capacity is. If they increase that, then they would require an expansion of the special use, because like any special use, there's parameters around that. So if they say you have to specify, then if they came to the department to get the permits and they said, well, yeah, we're going to add on to the substation, we can create this much more power with the technology of a repower, then say, okay, first we have to expand the special use because you're expanding the original use.
Matt, Chairman, just for a second. Matt, I know the law is very clear what's in and out, but, and I'm so proud of Tazewell County. Tazewell County, especially our zoning department, they approach these issues that come up and they know what to do because of their experience, not just the director, but the staff. And then when they run into these new things where you got a leg in one and another leg in another, then they got to think a little deeper. And what they usually do is come up with what they think ought to happen, go to the land use committee, talk to us and say, what do you think? And then sometimes if it's serious enough, she'll actually recommend a change back that comes back to ZBA for the ordinance. So it's almost like music, the way we play it here. It works really, really well. I hope the citizens and the businesses appreciate how good we are here in Tazewell.
Okay. She's noted your discussion. Okay, others?
Lighting plan in paragraph 153-05, design and installation. They wrote something in here about a lighting plan and lights shining outside of substations. And I can understand the need for having a substation well lit for the safety of anybody that's got to go in there and work at night, plus security.
Is that 4B, Todd?
Yes.
Yeah, 4B, I'm sorry. Safety and security of people that may be working around there. However, I think we ought to look at, is there a way that, I know in my community, we don't allow lights to shine off of one property onto another. Is there a way that we can do that?
That's what I was going to say. She's going to look up our lighting code.
Okay.
So we do have current lighting requirements that require that lighting such as that be shielded, so that it doesn't become a nuisance to a neighboring property. If you wanted to include something in this ordinance, but I would ask that maybe don't necessarily make the recommendation tonight, but let the land use committee think about that, and I can come to them with additional information about what's in the code, just so we don't get conflicting information from one code to the next.
Because we don't want to do writing that contradicts what's already in it.
Exactly. I just want to make sure that we're at least considering it. The part about the lights on the wind, or up on the towers, FAA is going to drive that train for you. There's probably not a whole lot you can say. They're going to tell you, we want these LED lights up here. I don't think you can shield them from the ground, because if a helicopter's coming through there at nighttime flying low, he's going to want to know where those towers are. If you shield them from the ground, he may not.
Yeah, I agree that that needs to be,
That's their
all
job.
of those guidelines, and I understood the discussion of, some of them blink fast and some of them blink slow, and some of them are a dark red and some of them are a light red, type situation. And my personal feeling there is, this company over here bought theirs from John Deere, and this company over here bought theirs from Case IH. And
well, that's why they're red.
And so that's the difference between the two.
And I think the FAA now requires all the towers in a field or in a farm, for lack of a better term, they all turn off and turn on at the same time. Because when they get blinking, it hypnotizes pilots. So they turn them all off and turn them all back on at the same time on the newer places.
Okay, other discussion?
A little farther down in 4D, warning of placards with warnings about high voltage and notification or who to call if there's an issue. I don't know what we require now, Jackie. Do we require anything at all?
So the addresses are noted there. I don't think it's a bad idea to have the information out there. I don't know which ordinance I included it in, if it was this one or the other one, but I would agree with having the information at the site, if nothing more than just near the address of the facility operations manager, or their
Or a phone number to call in case of emergency other than 911. And certainly at the substations also.
It's like the sign on the railroad tracks. If you see a problem, call this number.
Yeah. How's my driving?
I don't have one of those signs. We did go over railroad tracks last week in Tazewell County. I'm going to say it's the worst one in Tazewell County. And they were there working on it. And so we stopped and rolled down our window and said, please fix this. This is terrible. And they go, call that number.
What city were you in?
I was in, I think it's in Delaware Township. I don't think it's in Boynton Road.
Yeah. You've been on it?
Yeah.
So Todd, I didn't want to speak to this because I've read and rewritten this so many times, but it does say under 153.08 under complaints, the first section is all complaints should be made directly to the operations facility manager or their designee. Contact information for the facility should be publicly accessible via a facility website and at the point of access to each tower site.
Okay, great, perfect.
Okay, other discussion?
You might designate a minimum sign size, and so it's not a postage stamp.
The only other thing that I had marked, a little asterisk, was about the every, 24 months that county hires, conduct some like inspection type thing on, I guess the sounds and all that to make sure it's still in compliance of course, at the expense of the company facility. Thank you.
Okay, so.
Yeah, I mean, just because.
Are you at the bottom of the second page, the I?
Yeah,
Okay.
that was the other thing that kind of struck a little to me that,
Okay, but what you said, what this reads, I interpret as two different things. This is talking strictly about noise and acoustic testing.
Correct.
Okay, but you had said, inspections.
Well, I guess that's what I meant as far as a qualified person to inspect or.
Okay,
To make
so
sure.
it's not necessarily. Okay.
Hi.
I lost. Okay,
Where the schools went to ZBA.
so are you referring to general inspections or that what they're referring to? Because I think somewhere they also
Well, I mean, yeah, there was
indicated
another
general,
thing in there too about
general
inspection, so I guess,
inspections.
yeah, let's put it all together, because I do feel that it should be to make sure that they are still in compliance. It's just like with anything. I mean, think about businesses. I mean, about power plants. Power plants have to go through inspections to make sure they're all still running the same way. It's the same thing.
So would you have them submit a report that states that they're in compliance with the Illinois
Yes.
Pollution Board?
Yes.
Or are you talking about a county employee going out with
No.
one of them and inspecting everything?
No, I'm talking about having qualified personnel.
Okay, but
And the report would go where? Sorry.
Well, it would have to make sure they're still in compliance with the, I mean, okay, I guess as far as like where it was stated that to make sure that the sound and everything, because as you upgrade things and as you change things, or as things get older and don't work the way they used to. I mean, we're not talking about something that's just a 5-10-year plan. This is something that is 50, 60 years beyond. And so you can't, I mean, I just feel like as things get older or things change, we got to make sure that they're staying. We can't just be like, oh yeah, okay, you're fine, and never have anything tested to make sure that they're still in compliance.
Right, okay, would the report go to the county or not?
Well, yeah, why wouldn't it come back to the county to make sure that they're still in compliance?
So as I'm understanding it, it would be testing that's done and a report that's given to the county every 2 years that
Every 2
states
years.
that they're in compliance of the Illinois.
Yes.
Let's see. Is that happening now? Or
No. Right now, things are complaint driven.
I see.
And as I said, when Kelly
So
was
it's a
up
little
here.
more proactive, right?
Yeah, it would be more proactive. Right now, it would be
Thank you.
It's just, I mean, as a county, state, I mean, our hands are tied now through the state. So I think we, as a county, we need to do all the extra little things that we can do to show the people of the county that we do care and we are going to take care of them. That we're not just like, oh, okay, here, put them in. The state says we have to, and this is what we have to do. But I think we just need to set a little bit more guidelines. There's a lot of things that came up tonight, and I think it was mainly because we only had a few speakers, and it was a lot easier to stay in tune. But there was just a lot of things that kind of came up tonight that really struck me, that I do feel are important. And with all the changes, with what we're set by the state now, which y'all kind of called this, I think a year ago, when I remember sitting here saying, if we don't be careful, the state's going to step in. Well, here we are. So I'm just, trying to take into consideration of
Various factors.
Yes.
Okay, other discussion? Question, discussion?
Who's doing the testing on that? Is that a third party vendor or is that just the company themselves?
No, I think it has to be a third party. Yeah, absolutely.
Either that or somebody that's specifically trained and certified
Yes.
who works for the.
Yeah.
That would be legit.
So
Or
the suggestion from the testimony tonight says that the county hire a qualified acoustician and bill them for it.
That's not probably gonna
No. And so, yeah,
Well,
that
the
would
cost
need
of
to
the,
be debated and worded
the
at
cost
land
of
use.
to conduct the testing should be paid though, it should be expense of the facility owner. So it's not gonna be an expense to the county.
But the expense of the facility owner, so if they have a licensed acoustician on their staff or available to them, their own employee can do the testing, complete the report, and submit it to the county.
See, and that's kind of where I don't think.
You don't like that part,
No, I don't think the facility should be the one, I mean, come on.
Well, I'm just saying.
I mean, that kind of defeats the whole.
You're saying all kinds
I mean,
of scenarios. and so,
Right, but, yeah.
Well, if you commit fraud, you lose your certification. Your certification doesn't come from the one, that comes from.
Yeah, an outside source. So, okay, it's something for land use to consider. Other.
Take care of it.
You've got the
Decommissioning.
yes, where the property owner becomes liable for it, okay.
Yeah.
All right. And then there was a comment about liability insurance. I don't know if there's a law that, you know, the state puts a limit on how much insurance they have to have, or can't have $100 million worth of insurance for each tower or anything like that.
I'm saying yes, nod behind me, so yes.
I think they have to have certain financial assurance to cover all that, right?
Okay. Other discussion? Okay. You have something? Okay. The first thing is we want to make sure and include the setbacks or those things we discussed at the beginning, EcoCAD on down. Okay. I think Jackie's got all that. And then we've discussed a variety of different things since then. Okay. And so the chair would entertain a motion, or you can make whatever motion you want, to recommend approval of 23-30A, the proposed amendment to the Tazewell County Wind Code as written, with the suggestions to be considered by the Land Use and County Board for final approval.
I'll make that motion.
Long moved, McClanahan second.
You did that so well.
Further discussion? Okay, so since this is treated as itself, it will be a roll call vote. Okay?
Coopey,
Yes.
McClanahan,
Yes.
Meisinger,
Yes.
Vaughn,
Yes.
Chairman Lester.
Yes. Okay, is there a motion to get 2331A on the floor? It comes from Tazewell County Land Use Committee, proposed amendment to the solar energy system. Meisinger moves
I'll second.
and McClanahan seconds. Yeah, Meisinger moved and McClanahan seconds. Okay, this is like the previous one, just like on Tuesday night where we included all of those limits provided by the state. We need to include all of those in this code. Okay, he's going to briefly go over.
These are the ones that I noticed the statute allows that are not in the amendment as proposed. And the big one is the limiting the height of the facility at 20 feet is the lowest height. That's probably. And then you can require the developer to provide the recommendations from an EcoCat report. You can require the developer to comply with the recommendations in the portion dealing with the natural resource review. You can require the developer to provide you the results of the U.S. Fish and Wildlife Service information for planning and consulting environmental review report. You can require the developer to demonstrate that they are avoiding protected lands identified by DNR or the National Nature Preserve Commission. And you can require that they consider any additional setbacks recommended by DNR. You can require them to consult with the State Historical Preservation Office. You can require them to enter into road use agreements to cover the reasonable cost of improving and repairing roads that are used for construction, insofar as the road work is uniquely attributable to construction of the facility. You can't just say, you got to upgrade all the roads in all these townships to X amount. And you can require them to make repairs to drainage systems which are damaged during construction.
And screening.
Well, that's already in the amendment as proposed for solar. So that's already, yes.
Screening's already in.
Yes, I left out, and there's also setbacks that are listed in the amendment already, fencing, noise limitations, decommissioning, and vegetation plan.
Oh, don't take those out.
Don't take those out, leave them in.
Any other discussion?
Can I ask a favor of Matt? Will you put those bullet points for both wind and solar in an email and send it to at least the ZBA and the Land Use Committee?
So I'm giving Jackie my copy that indicates which ones are already in the statute. I can send you, I have the full list of provisions for each one, and I'll send that to Jackie, and she can send it on. Is that okay?
And let's go through Jackie, because this is where we're gonna get all our.
Yes.
Listen to Jackie.
So I like Matt's idea, no higher than 20 feet at full tilt.
Yes, I think that needs to be included in there.
Yeah.
Go ahead.
Minimum height of a fence of 7 feet.
I agree.
And as was suggested the other night, galvanized poles, not wooden poles, so it doesn't look like a concentration camp. Because they're exactly right.
Yes.
Yeah, you drive by that one on Springfield Road, drive by the one on Route 9, and that fence looks hideous.
It's what time? It's
Hideous.
Hideous. And
well, remember when he said it looked like a wood post with a wire looked like concentration.
yeah, that's what I said. And I'll use the microphone that way everybody can hear me. And the thing I worry about wooden post is, they're treated post. However, 10 years from now, some of them will be rotting off, and a good windstorm will have fences down, and then, you got to get people back there to fix all that. And galvanized posts just don't have that issue for a long period of time.
Hopefully they won't rust off in 30 years or 35.
Well, the life of the field, yeah, hopefully.
But as discussed the other night, and I don't know how the act refers to it, but we talked a lot about maintenance and trash in the fence and mowing, and I think Jackie covered that pretty good, that we have a lot of that stuff. So if a galvanized post would rust off and the fence start to sag, that's in that maintenance.
And then
plan that they have to submit and follow.
And then the other item I'd like to see is the same statement that we use for wind, that if it's decommissioned and the full price isn't paid or they leave, then the property owner, or the owner of record is responsible for finishing up the decommissioning of the site.
Okay.
And I think there's an added caveat in there, if they don't do it within a certain, I think it said 6 months, then the county does it and they bill the property owner. I don't know if you want that in there, but.
Yeah, that's up to the legal people to figure out how to word that best. Okay, other discussion? I'm looking at my notes here. Yeah, we've got that 20-foot height limit EcoCat road use agreements. Other discussion? Okay, the chair will entertain a motion to approve 2331A as written with suggestions noted to be considered by land use and county board. Moved by Baum. Seconded by McClanahan. Any further discussion? And this will also be a roll call vote.
McClanahan? Yes. Meisinger?
Yes.
Baum?
Yes.
Susie?
Yes.
Chairman Left.
Yes. That concludes tonight's meeting. And how many cases do we have in June?
Tomorrow's the filing deadline, but we
Lucina, you can keep coming and join us.
Oh.
Well, that can be almost as.
It's chickens.
Yeah, like I say, at least we're not throwing in ground rules. Even though Tuesday I was wishing for an in-ground pool.
Adios. See you next time.
Okay, that's done. Since I talked to you last night.
Okay, Tuesday was
Test flying
I know, and then everybody's testimony was just
so then Wednesday morning, yeah, that was the late. So Wednesday morning, we go. My brother says, man, there's an awful lot of heat around this oil field. Still got a supplementary list, but I'm probably. I appreciate it. And it has its own deal. So I said, well, let's wipe it off. And I grabbed it. So I went ahead and I had somebody who thought, I'm going to get one more. Oops. So we turned on the hydraulics and turned up the stove used. So, that was, I said, it's a new blender, so I didn't have one that stopped. So we just. So that took a bit.
So we dig it all apart, monkey about half an hour. And every time I start it up again, it runs for 10 to 15 minutes. And so I called the implement dealer Ross in Harrisburg and they go, today's the week for all the Ross, there's nobody named Ross here. I go, oh yes, I saw that in the paper. And so I thought, what do I, well, I called bottom line. And he goes, okay, that blinking line means that that little electric motor is not processing the voltage that it